ಸ್ಟೆನೋ ಯಾರು ಬರ್ತಾರೆ ಅಂತಾನೆ ಗೊತ್ತಿಲ್ಲ. ಸ್ಟೆನೋ ಯಾರು ಇಲ್ಲಿದೆ ಬನ್ನಿ. ಯಾಕಂದ್ರೆ ಲಿಸ್ಟ್ ಟು ಎಲ್ರಿಗೂ ಬೇಕಾಗಿಲ್ಲ.
Sorry, we are late today. We have to apologize. Yes.
May I please, my lord? In pursuance of the direction given by the government of Karnataka, Mysore Sales International Limited, it is a premier government of Karnataka undertaking, which imported natural river sand from Malaysia during the year 2017 and 18, my lord.
What is the issue? What is the mentioning?
The issue is now the Adani port people have taken over the Krishnapatnam port in Andhra Pradesh, and now they have issued public action notice to sell the sand belonging to MSIL, my lord. On 10/7/2018, the 24th they have issued notice claiming amount of rupees 88 crores, whereas the total value of the sand itself is 23 crores, my lord. And on yes, we have strongly objected.
The matter on board today.
Pardon?
Is it today on board?
Yes, my lord. We have filed writ petition challenging the legality of the public action notice issued by the Adani Port
This
Private
matter
Limited.
is which court? Is it court one?
No, it is at the scrutiny stage, my lord. Therefore, the matter is very urgent.
Which court is it? This court or the
The portal number 2, my lord.
No, just see it, ma'am.
If your lordship's kind leave.
Yes. Huh?
Still they have filed.
No. Is it court?
Is in scrutiny stage.
Oh.
You wanted it to be preliminary hearing posting. That's all. Fresh matter, you know.
Fresh matter.
That's, if it is in order.
We don't know what is the issue.
This is still in the form of. Filing not
See, we have to see which roster is this, which court is this. Unless we are clear, we can't. We have to, yes, sir, secretary.
Find out where it should be.
Yes, Mr. Kulkarni.
One, yes, writ petition, SCAT writ petition of 2018 year. Yet to be posted for preliminary hearing, B group.
What is the issue?
Estimates he is retired, some back wages are to be paid to him and he is 75 years
Just
old.
give it, ma'am, take it, get it listed.
I am grateful.
After 2-3 weeks. We'll give you a convenient date, Mr. Kulkarni.
Yes, perhaps.
When the award passed by the industry tribunal, granting the back wages, no reinstatement because he attained the age of separation during the year 2010. No matter because of the pendency of the writ petition. It's a division bench matter, writ petition, my lord. I'm not in a position to work out any remedy. He is aged 74 years.
What do you
In my
want?
favor,
What do you want?
my lord, any date convenient to the,
Is it a pending matter?
it's a pending matter.
Okay. Now, who
2020
is
matter,
the-
whatever date convenient.
Have you informed the other side?
Yes, my lord. Hold on, let me
Just
give
give
it a
it.
red copy here.
Just give it after
Whatever date
3 weeks,
convenient.
any convenient date.
Hello.
Yes, ma'am.
The Honorable Single Judge has struck down para 83 of the Employees Provident Fund Act scheme and 43A of the Employees Pension Fund.
What is the
scheme.
date of that order?
25th April 2024.
Okay, you have
So,
filed the petition?
yes.
Appeal.
Appeal is filed and
Yes.
it is due for coming.
Objections removed.
Yes,
You want to get it listed?
yes.
Just take it.
It may be posted tomorrow or day after. Your
We will
Lordship.
give you a convenient date, man. What is the urgency?
No, because the other employers are trying to get the refund of the amount, saying that the
You have got
stay,
it?
there is no stay in the.
Sis? Oh, ma'am, this will go to court one.
Yes, but a date.
No,
may-
you have to, then it will be only thing is possibly we can have it day after tomorrow or.
Day after tomorrow, it may be
No,
posted.
one, just give it on 12th.
No, troubling lordship only for a limited purpose.
To check up that. Have to check up, please. Yes,
Lordship, there's an arbitration writ matter. Lordship has issued notice, has not given me emergent stay
date of this roster, which roster?
roster, this roster. and service is not getting complete. I'm troubling lordship only for the purpose of list.
Say you appeared on that writ
So my knowledge,
This is another-
I-
This is another matter, lordship, another writ matter concerning arbitration. Lordship has given an emergent notice but not stay, but now service is not getting completed. Lordship accommodates me, one of these days I can.
take it. Yes,
They-
see.
I've not.
Great,
I'm
great.
mentioning a matter, PIL
Yes.
matter.
That Mary George, that writ petition.
What do you want now?
Lordship, if accommodates me on one of these days, I can ask for substituted service only for that limited purpose, because otherwise service is not getting completed.
Have you deposited the process fee, made an attempt
Yes,
to serve them?
yes. Notice is not getting served. It has come back. Acknowledgement has come back saying addressee left. So I may be permitted to serve on the advocates.
We'll
That's
get it listed next week.
great.
My lord, I'm
Lords.
mentioning a matter.
Just 1 minute,
Lords kindly.
just one. Just give it to him. Just take this. Yes,
I'm mentioning a matter, writ petition PIL. Number 11997, the office of the having complied with. It may be listed.
see, do one thing. This PIL is court one jurisdiction. Mention it before the Honorable Chief Justice day after tomorrow. Okay,
Sorry, date may be given convenient date.
is it a pending matter?
In a fresh matter,
It's a fresh matter.
fresh matter. Fresh matter.
Get it listed. What is the urgency?
Urgency is a bit regarding the public interest litigation by the petitioner.
What is the prayer in? Is there any interim prayer there? Is there any interim prayer there?
Prayer is not there, main prayer.
Then I think let it, you mention it before the Honorable the Chief
Texts
Justice.
have been removed in July itself, it is not listed, so it may be.
Just wait for 2 more days. Okay? Mention it before the Honorable the Chief Justice.
Okay.
Yes, Mr. Pramod.
My lords, these are the matters pertaining to that increment, my lords, covered matter.
Oh, these are covered
Right.
matter.
So
When do you
could
want?
any date, my lords?
These petitions.
Yes, my lords, they have been served.
So
Six
counsels are
matters are
appearing
there.
for the other side. Counsels are appearing.
Not that I have not checked it, but it's covered, my lords. It has to be disposed of.
Just listen.
There are 6 matters.
This
Ashok.
for 2 days. This week. We'll have it on Saturday. It's a working Saturday,
Please, my lords,
319.
21st.
please. Much obliged.
So yes, Mr. Shetty,
Serial number 34 in first list, my lord. This,
we'll just come back to that
Yes.
list separately. Let's.
My lords, say, Kotal number 1 matter, serial number 40, my lords, medical education matter. Kindly take it, direct it for listing tomorrow, my lords, before the Honorable Chief Justice. Medical
Yeah,
education.
we are just taking the list, just hold on.
Please, ma'am,
Just-
please.
My lords, total one matter, my lords, education, medicine, the matter was listed on 3/9, my lords. And on the submission across the bar stating that the second round would commence from 15th, my lord. The matter was ordered to be listed on 13th, my lord. But however, on Saturday, on Friday, they have released the notified dates for the second round, my lords. And the last date for payment of fees is on 11th. It will be
You
taken.
can
up.
have it only, no, this is, you are mentioning a memo
Please, my lords.
for what is the otherwise the date?
13th, my lords.
13th, we can have it on 11th.
My lords, tomorrow, my lords. Last date
Or
is
it's
on
not
11th,
possible.
my lords.
We'll have it on 11th.
Please.
11th.
was selected for Ayush course in the year 2000.
What is the mentioning being made? Is it for listing or
Listing, my
what?
lords, for listing, my lords.
It's a fresh matter?
Matter, my lords.
Which court? One or two?
One, my lords.
What is the matter?
Lords, petition was selected in 2022 for Ayush course, my lords. However, she didn't join the same because of her mother suffering from cancer, my lords. However, my lords, this year she wants to get admitted in the same course, my lords. And admission has started from today onwards till 11th. my lords.
Till 11, we'll have it on 11th. Just 11th.
Thank you.
Before the roster bench.
List number 2.
Two.
List number 2.
Serial number 40, it is medical education matter. Kindly take it up on 11th, my lords, 11th, serial number 40, my lords. Medical education matter contempt. Honorable Chief Justice has specifically,
Yeah, we'll just call the matter. Just hold on. We are calling the list.
please, my lords.
List 2, serial number 1, Shri Subramanya Upasana,
Re-notify.
For the appellant.
1610. Serial number 2, Shri Nataraj Ballard,
Re-notify.
2110.
Continue giving the dates.
Serial number 3, Government Advocate,
That's a short date, my lords. Directions has not been complied.
24-9.
Grateful, my lords.
Serial number 4, 14%.
Yes.
Your Honor, objection has been,
Huh?
objection is completed, Your Honor.
There are
Yes.
there are objections still.
No.
Our report says 6 office objections.
Complete.
Okay, very well. Just re-notify.
Delay is 20 days is there, Your Honor. Kindly
Just
condemn the delay, Your Honor.
Sir, 27-9.
27 September.
27th of
Around
September.
40%.
Yes, next.
Serial number 5, Shri Veerabhadra Gowda.
Re-notify.
24-10. Serial number 6, Shri Shahbaz Hussain.
Re-notify.
28-10. 7, Shri Srikanth.
Give on date.
28-10. Serial number 8, Shri Nikit Bala. 9-10. Serial number 9.
I beg to
May-
appear for the complainant. May I request not sometime in the last week of this month?
9.
Serial
Nine,
number
my lords.
sir.
What was the order to comply with?
What's the order was to, there was a direction to do the Podi and Duras in respect of an application which was made in 2019,
Thanks.
We'll seek instructions, Your Honor.
Just re-notify it.
last week or.
Just see it. Wait.
14,
Serial number 1, my lord.
14-10.
Any shorter date? my lord?
It's all right.
Very well.
See,
Serial
otherwise it doesn't permit the board.
Serial number 10, Shri Arun Govindraj.
Re-notify.
14-10. Serial number 11, Shri Shant Kumar.
Re-notify.
15-10. Serial number 12,
It's 12 also, my lords. I beg to appear for the
With the same day,
complainant.
same day.
Same day, my lords.
14-10.
1410.
Next.
Serial number 13, Shri Chandrasekhar.
Appear for the board.
13, sir.
Re-notify.
For A1. Board. My senior A1.
Compliance.
My
Whatever
senior
it is.
applying for A1. A1 is no more. Our name may kindly be shown.
Pardon for
A1.
A1. Oh, it's there already.
He is no more.
Mr. Oh, is it so?
Yes.
Who is now the council?
We are having a joint in Vakala.
What is your good name?
SS Parikshit and BR Raghavendra.
SS Parikshit and just note.
BR Raghavendra.
The registry shall notify the name of so and so advocates as counsel for the counsel for A1.
A1.
Okay, re-notify.
23-10. Serial number 14,
Re-notify.
14, I appear for the
14, 16-10. Serial number 15, Shri Chandrasekhar.
Re-notify.
My lord.
16, 16-10.
Appear for the A1 in this matter. There is a stay by the Supreme Court. I should not deposit any further amount,
We'll just re-notify it
please.
so that you can make the submission there.
Which serial number?
16-10, sir.
31. Sorry, 16.
Serial number 16, Shri Gopal Krishna Gowda.
My lord, in this matter.
Oh, you are talking of 16?
Yes.
Not
sorry,
15?
Not 15.
Okay, just 16, re-notify.
22-10. Serial number 17, Shri Ravi, SK Ravi.
Re-notify.
22-10. 18, Shri Sanjeev BL.
Re-notify.
29-10. Serial number 19, Shri Karthikeyan.
My lords, in this matter, I am appearing for the respondent, impleading applicant. My lords, the office objections have been complied. The office has not notified, my lords. It may be, my lords, translated copies are being furnished. My lords, office may be directed to verify it, my lords.
Re-notify. How many objections were there? This is
My
on
lords,
that
there were
IA
5 objections. I have cleared it, my lords. Office has not notified it, my lords.
IA 5 of 24, no?
Yes, my lords. That
Just
is the impleading
re-notify.
application.
Re-notify on.
24-9.
So, much of it.
Serial number 20, Raghunath. 20,
Notify.
Complaint. Appear for the respondent.
26-9. 21, Srimati Manjula Tejasvi.
Your Lordship, I'm appealing for the appellant in this case. I may kindly be permitted to serve copy on the counsel appearing for in the connected
Yes.
matter, Your Lordship, contempt petition.
Re-notify on.
21.1, I appear for accused, my lord. Both may be called together.
Yes, we are doing that.
15-10, sir. Serial number 22, Shri Rajeshwar.
Complainant, my lords. Okay, week's time, my lords.
So you have to take steps to
Yes,
serve the other side.
I'll do
Just
it.
serve it. Take
I'll
it.
file it to him.
2510.
Yes.
23, Shri Adinarayanappa.
We notify.
2210. Serial number 24.
We notify.
2110. 25, Shri Sagar Shastri.
For the complainant.
We notify.
30th October. 26, Shri Swami.
I appear for the accused lodge.
We notify.
27/9. 27, Shri Ravi HK.
For the accused.
We notify.
27/9. Serial number 28.
Lord, I appear for the complainant. Lord, this matter, I'm only making this submission for this reason. They were supposed to have filed their compliance affidavit. My Lord, directed on 24/4, subsequently by your lordships on 16/7, then by the Honorable Chief Justice on 21/8, then by your lordships on 28/8, then, my Lord, the latest, my Lord, on 4/9, my Lord, that day the matter on Thursday, my Lord, when the matter did not reach, when we made a mention, my Lord, the Honorable Chief Justice said, my Lord, that compliance report to be filed, affidavit to be filed, and such a short date was given. My Lord, from so many months, Lord,
In this matter, your lordship, the learned AG appeared.
Lord, this is the submission they've been making.
The learned AG appeared on last day, my senior.
It's all right,
colleague was
it's
there.
all right, yes.
On the last date itself, the chief justice said, the matter may be posted on the 12th. The senior counsel insisted the matter be posted today. Now, your lordship, the learned AG will answer. He's otherwise busy today with.
See, compliance affidavit should be filed now, whatever is the stand, so that he should know what is the stand.
Yes.
Because since he is appearing, we'll bring it to the knowledge of the learned AG, your lordship. Kindly have it on.
Very well, we'll have it on 12th.
12th, my Lord. Lord, because what they're saying, my Lord, last time it came before your lordships, my Lord, the same advocate made the submission. My Lord, the AG in fact appeared before the Honorable Chief Justice. In fact, he said a review we have filed. My Lord, then the learned Chief Justice, my Lord, Honorable Chief Justice said that review is not there, and there is a judgment of the Honorable Supreme Court which we gave. That review cannot be a reason for not complying. So, my Lord, and then they asked whether the review could be tagged. My Lord, the Honorable Chief Justice said no. And, my Lord, the very fact that 2 short dates have been given by the Honorable Chief Justice.
All right, we are giving.
12th, your lordship may have it.
We'll have
And,
it.
my Lord, for filing of compliance affidavit,
We say nothing. Despite order, have they filed it?
they are not filed.
We leave it at his wisdom. Next, leave it.
12th, my Lord.
12/9, sir.
Oblige.
Serial number 29, Shri Pradeep.
We notify.
26/9. Serial number 30, Shri Tejas.
Notify.
Lords,
I appear for the respondent.
Appear for the complainant.
Yes,
Lords, I appear for the respondent.
yeah, we'll just have it on the, just re-notify.
15/10.
The interim order may be extended.
Interim order, if any, is extended till the next date of.
Obliged.
Deeply obliged.
31. Serial number 31.
Re-notify.
16/10. 32, Shri B.B. Patil. 4/11.
Lords,
33,
the other connected matters are on 17th. It could be had on 17th.
Re-notify.
17th of September, sir.
No, yes, please, Lords. This one. There are other 2 connected matters.
17th of
On the
September.
same issue, I
Same issue, my lords, rather appeal different respondents. That's it.
re-notify.
Obliged.
33, Shri Shrikant MP.
Complainant.
Counts.
Not though the state has issued an endorsement, Lords has not filed the count. Lords, the endorsement itself. Lords, no, in fact, Lords, according to me, Lords, the endorsement itself is Lords contemptuous for the reason that Lords, it is against the order of this honorable court, which is passed. I filed a rejoinder already, my Lords. Lords may have it, my Lords, on Wednesday or Thursday. Short date, my Lord, so that
We say nothing, we'll just re-notify. When you want to file it, file it.
For A6,
shorter date, my Lords.
17/9, sir.
Obliged.
for A6, our name may kindly be, because my senior is no more.
Matter?
Nimda.
A6 may not.
A6.
It has to be written as NS may not. XN typing mistake.
You are saying it's 34?
NS.
In 34?
In 33 itself.
33.
For A6 may not.
Basic so-and-so, just say that so-and-so appears for respondent number, accused number 6.
NS.
Next.
Serial number
34, my lords, my lord submitted submission, my lords, insofar as office objection. Shorter it, my lords, in.
I gave you, say
Please.
shorter date. You see the board
Please,
position
my
of
lords,
the
I
board.
understand, my lords, I understand.
Difficult. We notify.
24/9.
Published.
Serial number 35, Shri Chandrasekhar.
The shorter date, they have to file compliance affidavit. Any date in the next week will be good, man.
25/9.
My lord,
36.
shorter date.
It's all right, please re-notify. See, it's very difficult, the board position. How, what is the date given, ma'am?
36, 27/9, sir.
27/9.
35.
35, what is the date?
35, 25/9.
36, my lord, 2 weeks, my lord.
36, 27/9.
Please.
7.
37, Shri Sampath.
Will take steps, my lord. Kindly reach.
20,
Re-notify.
24/10, sir.
Please.
38, Shri Umar Farooq.
39, re-notify.
22/10, 39, Shri Uday Kumar. 23/10, 40.
My lords,
Sharon.
40 is medical education matter. My lords, may I have it on
Yes.
11th, my lord, 11th.
What is
Plus-
the urgency you said?
Medical education matter, they are in contempt of the order. 11th, my lord, second round of counseling, the list will be announced on 11th. Your lordship may have it this on 11th, my lords.
11/9, sir.
Grateful, my.
41, 14%, Shri Srinivas.
Re-notify.
24/10, 42, 14%. 25/10, 43, Shri Dhananjay Kumar. 29/10, 44, Shri Vinod
Appearing for
Kumar.
petitioners. For the petitioner, 44, I am for the petitioner, my lord, they have filed, one of the party has filed impleading application. I have to file objection, my lord.
File
Please,
it,
yes, ma'am.
re-notify.
22/10, sir.
My lord, interim order may be extended, my
Actually, more than if any to continue.
much.
45,
45, there is an urgency, my lords. May I request for day after, my lords? The reason is there is an auction proceedings which I have challenged in the writ petition, my lords. The auction is on 12/9, my lords.
Have it on 12/9.
My lords, may I request on 11th, my lords?
Have it on 12/9. We are having it on 12/9.
My lords, if it takes
11.
11/9,
grateful, my lords.
46, 46. Purnima Hatti.
For respondent 4.
28/10, 47, Shri Pattabi. 22/10, 48, Shri Pradeep Kumar. 4/11, 49, Government Advocate. 24/10, 50. I'm appearing
For
for the
appellant,
third
madam.
number.
Interim order based.
I have
In item
50, 50.
I have vacating for the stake. Kindly give the short date of file the vacating for the stake. 22/10, madam.
Next.
51, Shri Kevin Narasimhan.
51, I have instructions to withdraw with liberty to seek a review of the impugned order.
Before the Honorable the Chief Justice.
Please, may I request day after tomorrow, my lord, I'll file a memo for withdrawal.
We'll have it on 12.
Well, very grateful.
12/9. 52, Shri Pradeep Saukar.
My lords, I appear for the appellant in this matter, my lord.
We'll re-notify.
Please, my lord.
22/10.
Obliged, my lord.
53, Siddharth Urukar.
For the complainant, my lords.
Re-notify.
30th 10, 54, 29/10. 55,
My lords, connected matter listed on 17th, my lords.
56, Shri Jayadevaya.
Yes.
29,
I'm a appellant. 56.
56,
56, re-notify.
29/10.
29/10.
57,
Lord, I'm appearing on 57. I'm pressing for an interim order, my lord. This is the third time it's come up. And I'm pressing for an interim order. I'm told the other side is here. Can I just state the brief facts, my lord?
We'll do one thing, Mr. Chidambaram. Who is the other side?
I appear for Respondent Union of India, I'm here.
What is the urgency, Mr. Chidambaram?
So the urgency is that pepper, which is imported, is lying in the port. When by appear in the matter, appeal came up for admission. The Honorable Chief Justice passed an order, and I'll show your lordship the order. One page order. Just please see the order.
You can't, we can have it on 11th, day after tomorrow. That's the reason, since it has been heard by the court one, better would be to have it on that day, Mr. Chairman.
Milord, I'm only, I know, but it's fine, posted for final disposal. Your lordship may not be
Yes.
inclined to take it up for final hearing. But the interim order can be granted because the Supreme Court has granted an interim order. High courts have granted an interim order. And I'm requesting that the same interim order be granted because the pepper is a perishable commodity. I will abide by the same conditions which were imposed by the Supreme Court and Madras High Court in several cases of similar matter. Therefore, I am willing to abide by those conditions if the pepper is released to me. That's all I'm asking. The final hearing.
11th, Mr. Chidambaram, before the postal. Whether that would be appropriate. 11th or 12th, whatever is convenient to you.
Not before him by chief. 12 is possible. Huh? What shall I miss it? 21 or 12? Milord, 12 or 20? I'm just, give me 5 seconds.
Yeah.
What, 12th? Milord, one more request, my learned friend is here. The Honorable Chief Justice's bench on that day directed them to file a reply in the order and orally said you keep the files ready. Now, last time it came up, Honorable Chief Justice did not have time to take up the matter. He posted it to today. Let them file a reply, my lord. They're not filing a reply.
Lordships, whatever the questions, they are legal questions. They have taken instruction to make submissions that to meet the requirements.
They said, I think possibly they'll produce the file, let them do it.
No, if
It was
they don't
not
want
the-
to file, they don't wish to file a reply, I can't compel them. I'm just want them
Lordships,
to.
we have been instructed to make submissions.
So I understand he's not filing a reply because he should not take time for reply on that, on 12th. my lord.
Lordships, as far as the issue is concerned, it's already settled by the judgments of the Supreme Court, which we have been instructed to say so. One.
My request-
Secondly, my lords, as far as the urgency is concerned, we have been requesting, if they protect the revenue, they can take the goods. It is laying for more than 2 years. Obligation.
Number 58, Srikanth. 24/9.
Not for the interim prayer, not sir. Plenary hearing. With the interim matter, no, my lords. Just read a shorter date.
24/9. 59, Srinivas, 59, Srinivas. 28/10. 60, Shri Dhananjay Kumar.
Appearing for appellants, my lord.
22/10.
My lord, the property is going to be demolished on the coming days of February, my lord. There is an urgency.
19/7. Serial number 61, Shri Party in person, Shri Dinesh.
My lord, it's a fresh matter. It's about RERA. I filed a review petition also on based on writ petition. I have filed this writ appeal based on the RERA Act and rule. It is in my favor that single judge has not seen certain documents of mine and passed the order. I requested to post it earlier, my lord.
24/10. 62, Srimati Purnima. 23.
Lords, may I request your lordships kindly to have it on 20th of this month?
Is the urgency.
My lord, this challenging the impugned local awards and the opponents are about to receive the land acquisition compensation. I have filed interim prayer as well as
Sir, 23/9.
20th night.
20th, sir.
Oblige, my lords.
Serial number 63, Shri Suyog Herale. 23/10. 64, Shri Ganapati Bhatt. 2910, 65, Shri Handra Ningappa.
Stated, we have complied with the order. Right, you file it? No, you file the affidavit, yes, you will. We'll have to get the statement of accounts.
24/9, 66. 28/10, 67, Shri Madhukar
For the
Deshpande.
appellant one.
29/10. 61. Number 1.
Lordship's permission. Serial number 34, madam, that I am appearing for respondent. I have informed the petitioner also. Last occasion, your lordship asked me to get the instruction regarding payment and all. I will have to produce necessary receipts, my lord. He is, in fact, we have filed a chart, but he is disputing. I will short accommodation, my lord.
Very well, next week.
Any date.
57/9.
Serial number 39. It's a matter relating to MACP, grant of MACP.
Yes, we will hear this matter.
If your lordship should give me 2 weeks' time, I have informed.
Beyond that day, we will hear this matter.
Your lordship may give me 2 weeks' time.
No, Mr. Don't make such a submission, please.
I have informed Mr. H.
We will hear this matter.
Yeah.
Next.
Serial number 1. Shri Radha Krishna.
Appear for university. Respond.
One, sir.
Hear the office objections, ma'am.
My lord, I'm for the petitioner, my lord. My lord, I will submit on 19th or 20th, my lord, because I got a spinal problem under treatment. And 19th, I will submit, my lord. And the petitioner is my son only, my lord.
This matter pertains to education law. Education matter.
27/9.
Yes.
Serial number 2.
My lord, for the petitioner, it's a habeas corpus matter, ma'am. There are some office objections. I'll clear it.
Here's for the respondents. Mr. Billiapa. Yes, ma'am. I'll pass over.
My lord. Yes, my lord, if I may be permitted. My lord, is Chief Secretary, is it necessary to make them a party? That's one of the objections, my lord. It may be overruled. It's relating to a missing person, that's why.
Kindly see, no. It's not a case of missing. The allegations are that a further statement is given saying that he's been murdered. But a missing complaint would not fall within the definition of invoking habeas corpus petition. No? There is no allegations of illegal detention. It's only a case of missing, and then the further statement would say that he's been he suspected certain persons of killing him. So therefore, this may not be maintainable.
Right.
Kindly see the further statement made below. I'm sorry.
That's the stand taken.
Yes, that's the stand taken.
Please say, ma'am.
My lord, missing, I will concede, but if we are naming certain people, then my submission is that a habeas corpus will still be maintainable, my lord.
Yes, Lord.
It is not your investigation transpired, he is not. He is
No, no.
alive. He's alive under their illegal detention. Then what follows?
No, we wouldn't know. Our investigation.
Don't know.
Yes.
Exactly, my lord.
Stand which is being taken should be based on some credible evidence.
Yes.
Clear that this is what the position is. Suppose he is in the illegal detention. Then what follows?
Well, then she should say that,
Right, based on that stand, something,
no, they wouldn't say that. Their allegation is that he is missing. It is not their case that it is the illegal detention.
We don't know, my lord,
No,
where
that's
he
what they
is.
say.
Where he was last seen in the.
Kindly see the complaint, I'll read paragraph 20. That's the story now they've come up with. Kindly see the complaint they've lodged. It's a missing simplicity, nothing else.
That is
Then
the
the
first complaint.
Then to invoke the jurisdiction of this honorable court, they would make a further statement saying that they suspect somebody of having killed him. Petitioner also. 20, my lord. We will accept it. We will accept. We will accept.
Suppose ultimately an investigation concludes that he has been detained.
Then we will convert it into a fair and.
Mr. Bileka speaks, it is said that Mr. Bileka appears for this coming.
1 and 2, my lord. And the objection related to chief secretary may be overruled, my lord.
September,
My lord, any shorter date, my lord?
30th September.
From 12/7, he's missing. They are not doing anything.
19/9,
Yes, my lord. Obliged.
serial number 3, one more. 3, serial number 3.
No, I shall comply with it. There's some urgency, my lord. Well, there's some urgency in the matter. Urgency is this, not the petitioners, not our site owners, who have not who purchased the site not from the society. Not this honorable court, not remitted the matter. Challenge to report the extent that not certain sites not which are. Please, not should get not the report at page 633. Not it starts the operative portion. Yes, ma'am. Yes, ma'am. Please, not. Not please turn to not page 20, so 700, no. 700. Yes,
Second one.
second one. Correct. My apprehension is not by virtue of the operative portion of the order, not the committee says, not.
No, which are the paragraphs where you
Yes.
where the
I am referred to, no?
these petitioners
Very well.
cases have been dealt with.
Please turn to not para 29, not at page 700, up to not 33. 33.
Here, this paragraph, the case has been dealt with.
Yes, not my case has been dealt with. Please, not.
Who the office of justice? How much time?
Not
Weeks.
not 4 days, not.
Weeks time to the office of justice. To be notified next week.
Not can I make seek one indulgence? Not the committee now says, not directs the BDA, not to release, not the compensation, etc. Please,
We meet next Monday.
very well.
17, sir,
Very well.
17/9, sir.
Please.
28 to 33.
Yes, 29 to 33, and not even further thereafter, not the court deals with the findings, not finally, operative portion. Please, not. That is para operative portion, which is at page 713. Not that is para number 39, but then there is sub para numbers 1, 2, 3. That is page. Yes, yes. Yes, no, there are separate orders for others. So far as I am concerned, not this is the main not reasoning. Please.
17/9, sir.
Wait.
Serial number 4, 14%. Serial number 4, party in person. (2110). Serial number 5. JP Darshan.
For the petition in this matter, my lord, I'm seeking for a short accommodation to the complaint with the office objection. Please, my lord. Please. Grateful, my lord. 6 and 7, same, my lord. Please, my lord. Grateful. My lord.
2210.
Yes, 5.
No, sir.
None.
Sir, that is 5. That's serial number 5. sir.
5, please. No, my lord, 5. Please, my lord. Short accommodation for to comply with the office objection. Please.
Sir, 1510, sir.
Grateful.
5, 6, 7, sir.
Please, my lord.
Serial number 8, government advocate.
Last two occasions, my lords, they have been taking time. The Central Administrative Tribunal by majority of opinion has petitioner, my lords, is government.
State government.
The state government appears for petitioner, appear for respondent, contesting respondent.
The request of counsel for the petitioner.
Lords, any short date may kindly be given. Anil Kumar, my lords, is a petitioner number 1, who happens to be the government official against whom the contempt proceedings are initiated. Notes contempt proceedings, my lords, the Central Administrative Tribunal by majority opinion has opined that, my lords, that there is a prima facie case for contempt. And judicial member, my lords, has held that there is no contempt. Please.
That petition will lie against that order or it will be 136. Pick up that also before the Supreme Court. It is not where the contempt has been drawn.
Please. You've taken that. Very well. Any short accommodation, my lords, short date. May I request for 21st?
It's 2110, sir.
2110.
Serial number 9.
21, my lords, this month 21. 2110, 21-9 I'm requesting.
So this patient, sir, 1510.
Next.
1510.
Sir, vacation. Serial number 9.
1410 at least, please. 1410 because I have to travel from Dharwad. 1410.
Serial number 9, Sri Keshav Murthy.
Objection.
2110. Serial number 10.
I appear for appellant, my lords. I'll comply it now itself, my lords. Kindly permission may be granted to receive the court copies, my lord. My lords, I'll comply with the office objections now itself, my lords. Kindly permission.
2110, 11, 2110.
Huh?
2110. 13, 2110. 14, 2110. 15, 15.
Yes, I appear for the.
I couldn't find anything that helps me in the rules. I already told your lordships I won't make any further submissions. I've said what I'm very grateful. Your lordship may kindly. I'll leave it. Can I make one request? Would your lordships kindly make it an order of the court? I don't have instructions on the client for withdrawal. May I just, I'm so grateful, my lord.
This is his promotion from a back date after he has been abroad of all the charges.
Yes.
Although he has retired, your claim would be for promotion from a back.
Notional promotion and
Back date and consequential.
consequential benefits. That's really the short.
Yes, sir. I attend these people.
In the course of last day of hearing, we had heard for the respondents and then Kumar has sought time to take instructions. No, to look into the move position.
Please.
Move position as be entitled to promote from the back date and most of promotion from a back date, including the consequences.
I'm sorry, my lord. Would your lordships also record the fact that he's superannuated? Otherwise, it should not be a. I'm sorry.
The petitioner has superannuated
So,
independency of this litigation. He states that he could not find any rule which would entitle the petitioner during the in these petitions, the relief which he intends to seek from this court. If that be so, appropriate shall be for the petitioners to see the prayer as being sought, has been heard by Mr. Kumar for us. As much as the petitioner, if he intends to seek a promotion, most of promotion from the back date to the post of additional member
railway board.
In a fresh proceeding before the central.
May I seek one further indulgence from your lordship? Will your lordships also be kind enough to observe the fact that insofar as the disciplinary proceedings and the censure, punishment of censure, the in another OA, which I filed subsequently in OA number 516 of 21, by an order dated 12/1/24, the CAT has quashed the proceedings against me, and therefore there is no impediment from.
No.
516 of 2021, an order dated 12/1/24, 2024.
The authorities have also accepted it.
Yes.
Seek the relief as urged by him in these proceedings. Where has been sought as has been heard by Mr. Today in a fresh proceeding before the central administrative tribunal. Liberty is granted and full stop. The tribunal has to state that the handling of such proceedings, the tribunal shall decide the same in accordance with.
I'm very good. May I just, one final indulgence, I've asked your lordships for a lot, but one further thing. The time spent in these proceedings.
In accordance with law, that encompasses everything.
I just tell your lordships by 14, section. I bowed out your lordship. I bowed out your lordship.
It
Sorry.
will not arise now. Because January 24.
My learned friend's fairness is available in the CAT. I have no difficulty, but I don't know if he will appear. So, so great. I'm so great.
All the three petitions are disposed of.
Three, watch. Lord, so great.
In this case, I appear for the petitioner. My lord, the instructions are that, my lord, I am permitted to withdraw, my lord, withdraw the petition. No, my lord, we have This matter is good. The petitioner is the Union of India, my lord. The order challenged there in the, my lord, the please, my lord. Please, my lord. Please, please. With the liberty, my lord, the last line, my lord, with the liberty to restore the writ petition, my lord, if. Please, my lord, I'll let. Please, my lord, please. I understand, my lord.
Just take it out, or you will keep it. This is.
Please, my lord, let it be on record, my lord. Please,
Say that we will say so.
please.
September 2024. To say that we should draw the repetition. To stop. Though a liberty has been sought in the. Since we are of the view that the petition should be allowed to be withdrawn simplicity.
Please. Great,
The letter is taken on.
great.
Fifteen, 16 and 16.1.
Please, I appear in
16.1.
23540, my lord. I appear in. No, my lord, it refers to only one matter, my lord. 23540, my lord. That is not filed by point one, is it?
Then we move on. This petition further.
Please. Great.
Twenty-seven nine.
16.1, I'm sorry, 16.1 is filed by private parties, my lord. Sixteen point one, my lord, they were not the parties here also, my lord, in 16. Probably the affected parties might have challenged it, my lord. Please, great. Please, please,
But he may have something to say.
please.
Twenty-seven nine.
Great.
Dealing card. Seventeen. No, no. Which one? 17.
Here for the appellant. The respondents.
Respond
are-
to 3 and 4, we have filed application for withdraw the amount that we have deposited before this honorable court.
My lord, the respondents.
He'll have to dismiss.
Please,
You have filed the applications.
I have filed, I am the respondent. 3 and 4.
So now, what do you want?
My lords, we have no objection for them to withdraw the money, my lord, that is deposited before this honorable court. They are the home buyers, my lord. I am the builder.
You have got the amount.
There was a direction
Direction
by this honorable court.
Yes, which order is there?
My lords, may kindly have, my lord, the order dated 17/8/2023, my lords.
deposited this amount?
Please, my lords. I have deposited as per the check dated 12/6/2023.
And you succeeded before the appellate authority.
Please, I succeeded before the appellate authority and they have challenged in appeal. Now the matter is settled and they have agreed to pay us the compensation amount as well. While,
In terms of the appellate order, the tribunal.
please, as per the tribunal order,
They are paid you,
they have been paying monthly basis.
they are paying on monthly basis.
However, their execution petitions are still pending, my lord. It is pending before the court below.
We have filed an execution before this appeal was filed. Eight to 2024 was the date. It was
You're right.
IA 1/24 it may be. IA for direction.
A1/23.
2024.
A1/23.
24 for release of the amount. 8 to 24 was the date of IA 5.
What is served upon me, my lord, is memo dated 21/8/2024, my lord, seeking release of money.
With a memo or an IA?
IA also we have filed mercy. Previously, it should be 1 of 2024, my lords. It is filed on 8 to 24.
Bill was dismissed.
Please, my lord, for non-prosecution. On the same date, we have filed an application seeking recall, my lord. However, that is not, my lord, listed today.
That IA was also rejected as per the order, my lords. Their IA was also rejected subsequent.
Which date?
On the same date, 7/12/23.
Please, my lords.
They have filed it on the
My
same date.
application was dismissed on, my appeal was dismissed on 7/12/2023, my lord.
The application is-
On the same day, my lord, the order is showing, my lord, it is dismissed on the same day. I have filed it subsequently, my lord, after the dismissal. I filed it on the same day.
Which application do you have filed for?
My lords, I have filed an application on 7/12/2023, my lord, on the same day. I have filed a recall application, my lord, seeking recall of the order dated 7/12/2023. My lords, it is supposed to be, my lord. No, my lord, I am not precipitating on the IMA. Please, my lord.
This is IA. Not good.
For release of the amount.
It's IA 3 of 2023, my lords.
And 4.
Two and three. Two and three.
Please. Four,
After 2 weeks.
Great.
4-9. Serial number 18.
Wait for apparent.
Yes, who appears?
I appear for the second respondent.
This
Have you served the respondent number one?
postal share shows unclaimed, my lord, but in C.
Take a pairing notice was issued to respondent number one. So today, postal endorsement says the is unclear, states unclear, they say unclear. You have the report of the postal authority on the is on the respondent number one is to have been affected. What has to be done? You are here for.
I appear for the bank, R2.
You have your. Is
My lord, the thing is, the attached properties are secure assets of the bank. So I'm aggrieved because of the,
are these the matters are connected?
yes, my lord, that's at 20.
7 and 28,
27 and 28.
19 also.
Then this is engaging now come to the next one.
19. to Madhukar Deshpande.
Yes.
R2,
And
R1,
this also
R3 and
postal.
4.
Yes,
In 19, my lord, I appear for R1, R3 and R4, my lord. I've not filed vakalat, my lord. I request for another week's time. I'll ensure it's filed.
yes, yes.
Same. This is for R1.
R5.
R5. Respond number 5.
Teams. Five.
It was issued on. Postal endorsement states the report of the postal department. It's got the answer appearing for 3 and 4. You are appearing for 2?
Yes,
1,
ma'am.
3 and 4.
3 and 4 state the Vasala shall be filed within how much?
1 week's time.
It's the appeal. It's the appeal for the.
21-10.
Please.
20, 27 and 20. The other two, 27 and 28 also, my lord, the same.
28.
This 7.
This 5 years submissions of.
Yes, ma'am.
7.
In 27, my lord, I undertake to file wakalat for R1 as well. He's been served before the last day. R1 is being served, my lord. R2 is already represented. For R1, my lord, I undertake to file wakalat for R1. Yes, ma'am.
At R2.
I appear for 1, 3, and 5 and 28. R4, my lord, is the same as R1 in serial number 17, my lord, who is not represented. Yes, sorry, 18, my lord. My lord. Screen card. Screen card.
Yes, ma'am.
Yes, ma'am. One, 3, and 5, ma'am. Sorry, ma'am. Yes, ma'am. I filed wakalat for 1, 3. I'm not appearing for her, ma'am. I have no instructions to appear for.
Sir, 2110, sir. 2110.
Please.
Serial number 20.
My apologies, my lord. A week's time may be granted, my lord, for taking R4 and R5. My lord directed the learned counsel, my lord, to be served. I will do it, my lord, within 1 week and highlight. Within 1 week. my lord.
Additionally, he should also serve after.
Please.
2110.
Please.
2110. Serial number 21, Shri Prakash.
Lords, there is an application filed by the private respondents seeking for recalling of the orders. The reason is there was a delay of about 1,000 days and the delay is condoned before notice to the respondents.
Lordship's order stated 26/9 to 2023. 1,000 days. Though it is mentioned in the application, it is 547 days. Probably they seek to exclude that non-dice period as declared by the Honorable Supreme Court.
Lordship, regarding delay, I have filed the correct days, Lordship. Office is also calculated later. During the corona period, Lordship, calculated, Lordship.
That's
Already order is regarding, the.
26/9/23, it says delay condoned, issue notice to respondents.
Just tell us this thing. Service of Vijaya Karnataka was on.
Yes, I have produced. Yes, I produced it.
ಎಕ್ಸ್ಕ್ಲೂಡ್ ಮಾಡಕ್ಕೆ ಹೇಳಿದ್ದಾರೆ ಅದಕ್ಕೆ.
Just say this IA 1 of 24.
1, 2, 3 and 5.
Application filed by the appellant seeking condonation of delay. Submission of this that is application for the condonation of delay. So this witness so as this seek weeks.
Lordship, please, I have filed memo of calculation, how the calculation. Yes.
Please. 23.
My lords, in this matter, my lords, the synopsis is ready. My lords, I'll send it.
I have asked Secretary, sir.
Yes. Lords, that is, it has to be sent by mail, my lords. We'll scan it and send. Yes, my lords. Because it was the understanding, my lords.
Got your submission.
Yes, my lords.
It states that the same shall be filed through e-filing.
Yes, my lords. Much of. My lords, my lords, in this matter, my lords, the apex court has listed the similar matters on 14/10. Yes, my lords, because 28/1, my lords, it is pending, my lords, it was listed there on last Friday. It could not reach. Yes, my lords. 22.
And October, it may be.
My lords, 14/10 it is listed, my lords. Yes.
We'll give you 4 weeks to file it.
Yes, my lords.
511.
Much of it.
Sorry, copy. Yeah.
23.
Lords,
What happened there?
Lords, we made a submission that we are not acceptable for any settlement. The order is not uploaded. Our statement is recorded by the court and the matter is now posted for hearing, those matters. So the proposal for settlement is closed.
From my understanding, the parties were present on 5th, except for their authorized signatory, who was a signatory to the memorandum of settlement, my lord. Now, my lord, at least my understanding, because I'm not the counsel appearing there, my understanding is that on 25th, he's been directed to appear before the coordinate bench, my lord. 25th is the matter. He's been directed to appear before the coordinate bench on 25th, and then 25th, all are going to be present. The
Lords,
authorized signatory, my lord. They're
Lords,
representing.
I'm representing the present private respondent in that matter. Your lordships wanted to only accommodate, my lords. Lordships may kindly have the contents of the memo, my lords. That is already recorded. Our statement is recorded that we are not entering into any settlement in the matter. Matter is posted for hearing. And the coordinate bench said the parties' presence is not required for any mediation or settlement. But the court wanted to ensure that the parties are present when the hearing takes place. Because I was personally present when the matter took place, Lords, transpired before the coordinate bench. Lords, may have a look at the contents of the memo, my lords.
We come back to the same situation as what we were in the previous date, my lord, because now,
not
again,
true.
the coordinates bench says the. Please, I've seen the memo, my lord. I read it. Please, my lord, they say that they have no settlement. In fact, they had also filed an affidavit to that effect, my lord.
Yes.
But my lord, they
for
have still
hearing.
been directed to be present because all the parties have still
The-
been directed to be present.
the
because there
coordinate
is still-
bench, the
Now, rightly
coordinate
or
bench-
wrongly, there is a mediation report which is placed before the honorable coordinate bench. Now, my lord, whether that is right, whether that is wrong,
Even-
whether that can be
even-
enforced, all of that has to be looked at on 25th.
Lords, we even brought to the notice of the coordinate bench that section 75 of the Arbitration Conciliation Act makes the proceedings before the mediator completely confidential. There is no way that that could have been disclosed before the court. That's purely a report, my lords, which is for the consumption of the parties and the mediator. Not the coordinate bench considered the same, recorded it, and thereafterwards, at my request, it is specifically listed for hearing. However, the coordinate bench said that during the course of hearing, I wanted the parties to be present, but the matter is posted for hearing. The coordinate bench has already recorded the statement that there is no settlement from our side. So far as these proceedings are concerned, yes.
May I just clarify that point, my lord? No, in so far as the mediation report is concerned, what the learned senior counsel says is that it's confidential. It is confidential till it reaches court, my lord. No, my lord, please. The issue there is, my lord, whether a mediation report which is already placed on record, which is already settled for all practical purposes, whether that can now be recalled or not, by virtue of it being the party saying no, or by virtue of the court saying, no, I will not take this mediation report. Now, that is what is to be looked at there. And also, if there's a possibility, please. Please, my lord. My lord, 25th is again
Matter
for
for
the
hearing.
appearance of
My
the
lord,
parties.
Lords may see, the matter is posted for hearing.
Please, and also for the authorized signatory to be present, my lord. There is
That
a
is-
reason why he's been directed to be present.
That's absolutely nothing to do. They can't drag on the proceedings and then prevent the IBC proceedings, my lords. My lords,
That is the
there is
only-
nothing in this writ petition. Please, my lords.
Well, that's the reason we have it for today. For those proceeding may have a hearing here.
Yes.
For much is sought to be relied upon these proceedings which are pending in IPC as part of the proposal settlement.
Lords,
That's right.
yes. Now we have already said, my lord, that there is no settlement. We have filed an affidavit before this honorable court. We have filed an affidavit before that court. Now, if at all,
We will make this statement on record and we will.
lordships may dispose of this matter, my
May I
lords.
just seek my lord's indulgence? My lord,
Liberty
let
may
it
be
be
reserved to
after-
move that court.
Please.
Yes.
Let it be after the 25th, my lord, because 25th, there could be some scope where all the parties are present.
No.
The honorable coordinator bench itself may intervene in the matter, and then, my lord, we'll have some quietus to the matter, my lord. It's only after 25th.
That reason only will.
I do understand, my lord. I do understand, my lord. Please,
This is so, this was a-
please.
Now, statement has been made and-
Please. My lord, it is also for the presence of the parties, my lord, because that is my understanding as well, my lord, because it's not uploaded. Admittedly, it's not uploaded as yet. It would, my lord. Please.
Presence of parties, presence of the parties on the date of hearing means necessarily for settlement. What is being said is hearing.
Please.
That's all we are taking it. It is not
Please.
hearing.
my lord, I have, at least what, from what I understand, my lord, hearing as well as if there's any settlement as far as the mediation report itself is concerned, because the mediation report says it's settled. Now, can we have a different interpretation to it is what the honorable, again, my lord, which is why, my lord, one indulgence to say after 25th, my lords may have it, because 25th, if there's no settlement, there's no settlement. I do understand, my lord, I do understand. Please, which is why, my lord, with all due respect, my lord, I wouldn't say that shows the entire picture there, with all due respect, my lord, because that may not show the entire picture there. Because let the order be uploaded as well, because 25th, my lord, I'm only saying 26th, my lords may have it.
Lordships,
Please,
Lordships, may please. Yes, my lords.
please, grateful.
Serial number 24, Shri Viraju.
For respondent 2 and 3 in this matter.
Respondent number 5, my lord. Filing some additional grounds, my lord. I'm also ready in the matter. Just giving them a copy. The office objection is regarding the corporation, not for me. Just to highlight that the complaint would not disclose jurisdictional facts and making out a prima facie case, enabling the authority to satisfy itself as to existence of any act of land grabbing and to issue notice.
Respondent number 5, my lord. I am
But
the, I am the complainant.
I am for respondent 2 and 3, my lord, BBMP.
I pay for the state.
You appear for this. And what are the otherwise the proceedings, the position of the proceeding there?
My lord, it is now at the stage of evidence.
Stage of evidence.
Posted for recording of 313 statement of the.
Please just ask.
Please, ma'am.
Here.
Yes.
My
lord, I appear for the petition, my lord, my lord, I appear for the petitioners, my lord. My lord, that is an office objection, my lord. This is a matter pertaining to transfer by the Employee State Insurance Corporation. Nodal officer has signed, my lord. He was authorized to sign on behalf of the petitioners. The transfer of the respondent has been challenged in this, my lords.
Therefore, the tribunal say reconsider it in terms of your new policy. That's what the tribunal say, consider it in terms of your new policy.
My respect to submission, my lord, the transfer has been affected earlier to the transfer, this policy. My lord, at the time of transfer of the respondent, my lord, the policy was as in existence, they have done it. Now, my lord, your lordships are aware that the 20th 5/22 policy has been changed. Then, my lord, I think, my lord, that's that now the tribunal directed to set aside the earlier order of transfer, and they said you consider the respondent posting in accordance with the transfer policy dated 20th 5, my lord, the 2022.
But are there any other cases where they have challenged the previous transfer?
Yes, my lord, I think some of the matters are there. One matter your lordship said it will be posted on September, because in that connection case, my lord, the respondent has already given a posting pursuant to the order of the tribunal, and earlier that we have challenged that it came up before your lordships also. My lord, I think some other cases are.
Now, what are the office objections?
My lord, office objection is the nodal officer signature for the petitioner was not acceptable, they said, my lord, because the nodal officer has signed on behalf of all petitioners in respect to the State Employees Insurance Corporation.
So what do you say on that?
My lord, the nodal officer has signed it. Therefore, my lord, he is the authorized on behalf of the petitioner. I have produced the authorization letter also. Therefore, my lord, office objection may be overruled, and your lordship can consider it the case on the merit with regard to transfer of the.
Just say this, the office objection of the registry is over, insofar as the office objection put by the registry is concerned, the counsel for the petitioner submits that the nodal officer in the ESIC corporation, ESI corporation has filed on behalf of all the persons.
Yes, my lord, they are all party before the tribunal, therefore, actually, only the State Employees Insurance Corporation is the necessary party, they made it. Therefore, my lord, the nodal officer has signed on behalf of all of the petitioners. They're all, the others are, most of them are formal parties.
But do you have their concurrence like Secretary, Ministry of
Ye-
Labor and Employment?
My lord, they have been, nodal officer is authorized because the secretary is the only formal party. There is no adverse order passed against him or in favor of them.
The objection of the registry is overruled. Now tell Mr. Shetty, come to the merits of this case.
Yes, my lord. My lord, the order of transfer, my lord, dated 7/10/21. My lord, I think page 38 has been challenged before the honorable, the tribunal, my lord. Lordship, the petitioner before your lordship, the respondent is, my lord, the serial number 6 at page 38. Tejaswini. My lord, she has been transferred from Rajaji Nagar to Rudrapur. Then, my lord, on the same day, as per page 39, she has been relieved from the next, on
Where is
8/10,
Where is he posted today?
the posted to the Rudrapur, my lord.
No, where is he now working? Is he in Bangalore or in Rudrapur?
No, now, my lord, she is not working at all. She has not reported to duty and she is not working at all, my lord.
The others have reported for duty, the other six.
My lord, other 6, my lord, I have to check it up, my lord. That was the.
See, we are only concerned whether the others would also be seeking a similar benefit.
I think, my lord, my lord, others, my knowledge, my lord, most of them have not challenged it. If your lordship, I have to get the instruction from whether others have.
Have they joined the place of posting at Rudrapur? Because everyone has been posted to Rudrapur.
Yes, my lord, I see. That
if they
I
have-
had to get instruction, my lord, because my knowledge is most of them have not challenged it at all, I think. Anyway, my lord, I have to make correct submission before your lordship, then I have to get it. What happened to others, 7? My lord, may I request your lordship, may have it day after tomorrow, I will get the correct instruction, my lord.
Just say that at the request of Mr. Shetty, re-notify. Get your instructions.
Please, my lord, I will get it.
Give it Saturday.
21/9.
We'll have it on 21/9.
My lord, may I make one request, my lord. The 18th, there is a contempt case is there. They said they are direct the party to be present to the. Therefore, may I request earlier to 18th, my lord, subject to your lordship.
Okay, just have it earlier to 18.
17, sir. Sir, 17,
Please, my lords, please, much obliged, my lords.
serial number 26.
Here for petitioner lordship.
Siddharth.
Insofar as the office objection is concerned, annexure J lordship, I am not pressing the page number 223, 226 and 228. This is a lordship. Lordship, annexure L lordship.
Yes, 240. For the state.
There is no prima facie lordship, the lordship.
Will not take over whatever has to be done by the court below. You don't appear, if you don't put out your case, what they will do. These need to be put to the court concern.
Is annexure J lordship. I'm not pressing the page number 223 and 226 and 228.
the NBW has issued, your lordship. The petitioner, she has stayed in the US.
Appears to be that one.
That copy is only available in the sub-register office. We applied in the.
Who are in USA.
Yes, lordship.
Fine.
That is not only lordship, the annexure J is the scanned copy. It is which is available in the sub-register office. I applied. I showed the property to sites to third parties. The annexure J is the said deed, which I applied through sub-register office. It is available in the sub-register office only. That annexure, the page number 223 and 224 and is not relevant to the subject things. That's why I'm not pressing for the memo. Not pressing the page. Annexure J, lordship. Office objections is only that reason. Not legible is a 226, 227, the page number. Scanned copy is available in the sub-register only, that only if I applied that scanned copy. I sold the property. I'm stayed in the USA. The NBW issued. Already trial has been the completed and clearly categorically stated in the trial court also. I am not at all encroached the switch. Not civil suit, sir. Myself, 2019. 2019, I filed a suit against the injunction suit against the government. Stating that they are interfering my possession. I'm the property owner, lordship. I'm a site holder. The society is formed by the layout. The society got allotted the sites. I purchased the sites. This is approved by the BDA. It clearly says the annexure D, lordship. The Gundutopu survey number is showing that the government land. It's adjacent my property. It is clearly established in my suit also. It is already concluded.
This everything you have to say, tell to the board, not to us. The point, you will just go and file an application saying that.
Yes, sir.
Will seek the recall.
Through father, I filed a memo, lordship. I already sold the property. I'm not concerned this site also. They have not made a party to the purchaser also. The proceedings is initiated subsequent to. Special court, through my father, I filed a memo. They have rejected the memo, lordship. They have not accepted my memo. In the criminal proceedings, I am not through GPI, I cannot.
There is a finding on the aspect that there is an encroachment of 1,200 of.
Let's assume there is some justification. The thing is, you are in USA, how will they cancel the NBW?
NBW, lordship, further proceedings may be stay, lordship, because through my father, I filed applications and I filed along with the sale deed also. I sold the property. I am not concerned with this subject matter. The purchaser has to be necessary parties. I told before the court has not heard. Told the.
You have sold it?
We already, no, subsequent to decree, I sold the property 2023, lordship. Subsequent to sold of the property, there initiated the proceedings, this 2024. I'm not. Subsequent to the decree, I sold the property. Decided, lordship. In page number, injunction granted, lordship, permanent injunction.
Not to interfere.
Not to interfere, lordship.
But there is a bar under the land grabbing act.
Annexure J.
Filing of a civil suit, lordship. There is a bar.
You party, were they party?
They are party. Yes, Your Honor.
You take up
Yes.
an appeal then?
Is
They are not
coming. They are not served that cup. So that is-
Annexure G, lordship, if you see. The annexure, lordship.
today is the date before the court.
Yes, Lordship, there is.
There must be a report from US Embassy.
Already notice has been issued to the US Embassy. If the further proceedings, if it is paid, the threat of the arrest may be avoided, Lordship.
Have you challenged that?
No, we are not challenging.
The injunction is standing in her favor. Maybe according to its nullity, maybe for the report at jurisdiction. This has to be decided here. Now, according to her, there is a sale. He has sold the property. What was the report of the Tehsildar? On what basis the cognizance has been taken?
There is encroachment. There is an encroachment.
Encroachment, but she has already sold the property.
I'll take a report.
Okay, she has already sold the property. Is she in encroachment then? And she has already sold. Then
To that extent, I'll take a report. I'll take a report, Your Lordship.
The revenue inspector falsely stating,
they initiated, which she had already sold.
showed, Lordship. Even the false report has been submitted by Annexure M, Your Honor, which is an question before this honorable court. Revenue inspector subsequent to showed up the property, they are mentioned the name, my name also. So stating that they are in the possession of the property.
They rejected your memo.
My memo is not accepted from the court. I Cognizance, I filed memo, Lordship, through his father to GPA holder. The court says that in the criminal proceedings, we have not accepted the GPA through, we are not accepted. That hence issue notice, NBW, Lordship, straight away, last date of hearing.
Take instructions.
I'll take instruction.
Take instructions. The challenge in this. The petitioner had purchased the property. The petitioner number 1. Is that the petitioner, Ms. Sri Rashmi, has filed the action through the is the initiation of proceedings filed at the court on the basis of the report submitted by the Tehsildar that she has approached an area of 1200 square feet or
1,200 square feet.
According to him, the petitioner, he has filed in which addiction?
Annexure G, Lordship, OS number 1505 of 2019.
Power of attorney, which has been decreed in favor of the petitioner.
On 16 September 2021.
The injunction in her favor has decreed the court has decreed the suit. And in the following manner, page 18. He also states that even thereafter, the petitioner has sold the property.
At annexure
Getting that sale
18/3/2023. Annexure J, ink page number 1204.
in favor of Yes.
Krishnamurthy and K. Devika. Devaki.
Here, as is, in this regard, he has drawn our attention to page 99. But he submits that the Tehsildar report is dated
Annexure M. Ink page number 247.
It after the petitioner has sold the property to, where is that same deed, page number?
Page number 204, Lordship. Annexure J. J.
Is the date of the same deed?
18/3/2023. Yes, Lordship.
And that will show. Tehsildar report is 27. Here after she has sold the property. With her father. So in other words, it is sufficient that the proceedings have been initiated after the petitioner ceases to be the owner of the property. In property details. 249 A block.
Yes, Lordship. It's a farm by, it's a approved layout, Lordship. 1249 A block, AECA society.
In various survey numbers,
Singh Sandra village.
Begur,
Begur Obli.
South Bali, the report filed by the power of attorney. Power of attorney, like in the aforesaid facts,
Yes, Lordship.
has not been accepted by the special court. He also states that the petitioner is a resident resident of USA.
Yes, Lordship.
And non-bailable warrants have been issued for our visits. That the previous owner, the PDA has collected tax of 1055 from the previous owner. K. Ganesh is the previous owner.
Earlier, he was allotee from the society.
So has been shown in the khata, has been transferred in favor of the issue. This also appearing for the respondent one who appear for all the three.
All the three.
Seeks time to take instructions at his request. We notify on everyone.
Whenever, next week, Monday.
Tuesday.
79, sir.
Till then. Further proceedings.
So that it has to be executed through US embassy.
Already notice already issued to the embassy.
Please.
If threat, there is a threat.
Take
27 and 28 urgent. 29, Anish Acharya.
We have got the order. Senior will pass over.
30, Srimati Vanajakshi. 30.
Appearing for the state.
Government.
This is a matter pertaining to the challenging the constitutional validity of impugned act as the Mulageni Act. There's a status quo that is ordered.
We filed our judgments, we filed our written submissions as unknown. Second.
But the second matter.
There is some.
Very well, my lord. I'll take steps, my lord. One more matter is to be connected, my lord. On the same matter, my lord, Mulgeni Act is challenged. Writ Appeal 716 of 2023, my lord. It is not there. Yes, I'll file it.
All of you file your written submissions, Mr. Shetty, also.
Please, my lord, another 2 weeks we'll file it, my lord. Then the matter can be taken up any day after that, my lord.
To respond immediately to vote is still incomplete in writ appeal number 75 of 2000. Now, says that the respondents will be voted and resolved for the Tuesday appeal. This on this before the council for the parties shall file their written council for the parties appearing in this.
Meanwhile, Lord, may I request, I am appearing for, Lord,
Yes.
Yes.
May I request, I am appearing for respondent number 2.
In which matter?
That is
No,
30.2.
that is one just now, Your Worship, only this request, my Lord.
I'm led by Mr. Senior Counsel, Mr. A.G. Holla. He's appearing in for respond number 2 in 30.2.
Yes.
That is 726.
Yes, Mr. Hola.
Lord, one request, small request.
Yes.
That 111 grounds have been raised. May I, Your Worship, permit me to put it in writing something about it against them, because so many things are very difficult to remember also.
Let's hear the matter first, Mr. Hola.
Yes, I am, Lord, I am requesting Your Lordship's permission to put something in writing against the 111 grounds raised by the appellant.
That is in
It's all
what's
right, they are at liberty, but in any case, we say nothing at present. Only thing is the submissions be filed by all the appellants.
Because it will be easier for me to remember the points of.
Okay, do that. So file your submissions.
Yes. Yes, sir.
Written submissions be filed.
Please,
along
please.
with the judgment they want to rely on.
My lords, one request, my lords, the records before the single judge may be called for because there are plenty of citations that were relied on before the single judge. There are about 5 volumes on each side that we have relied on. If the same volumes can be continued before the division bench, that could be of some convenience is my request, my
Do
lords.
this.
Please,
We
my lord.
can ask the registry to scan it and put it on all this thing.
Please, my lord.
That would be better rather than, we
Also, my
also
lord,
having
some
it.
records had been called for from the state government. That is also on record, my lord. So that will also be helpful, my lord.
They just say this, learner counsel for the party states that the writ court record be requisition for hearing of these appeals appropriate for the registry be that they shall scan the writ court record and make it part of the record of these appeals.
Please, my lord.
For the next.
Please. Please. That would be very helpful, my lord.
Yes, you notify on, just give it after 6
One more
weeks.
matter, my lord. I'll give the memo, my lord.
Just file a memo, Mr.
Yes. It has to be clubbed along with this, which is why, my lord, unless there's
It
an order.
arises from the same.
Yes, my lord, same judgment, my lord, same act. Unless there's an order, my lord, they will not tag it. I'll give the memo.
But you should be memo.
I'll
you
give
want
the
a
memo,
memo.
my lord. I'll give the memo. That can be tagged.
You give a memo?
Yes, my lord.
You mention it anytime, we'll just make it.
Yes, great.
2910,
Madam, date of
29.
29. Please, oblige.
Sir, 29/10, sir, date.
Next, ma'am.
Serial number 31.
Same, ma'am, re-notify, we'll have it on 21/10.
21/10, sir.
Please.
Re-notify on 21/10.
32,
32 also same order.
21/10.
Yeah, we will have it on 21/10.
21/10.
Yes, there is a batch of matters being heard by the court one, so we'll just await that also.
I will also file my written submissions also.
Yeah, do that.
Yes, much obliged.
Serial number 33, Shri Kalyan R.
What has to be done in this?
Lords, filing my submissions, my lords, contentions, I am filing it. I have filed a synopsis also, my lords. I have filed my
Yes.
synopsis. And I am filing my, lords, brief notes of submissions. Aruk sir madara?
Mr. Bhagwat, you appear for whom?
R6, council for R6. Council for R6.
Okay, we'll just pass over. You ready?
Lords, I am ready in the matter. Lords, today afternoon there is.
We'll see, we'll just
yes.
pass over. Let's take a chance.
I'll say, please.
How long you would take, Mr. Ravi?
Lords, it may take some time, my lords.
The reason we'll just pass over. We don't want to block the board.
Very well.
Just pass. Let's see
Please.
if you are held up, please let us know.
All lords.
Lord, I may come 5 minutes late at 2:40 minutes.
No issue. He says he will have a difficulty post lunch. What do you say? We'll just pass over. Next.
34 urgent, 35. Serial number 35.
Serial number 35, request for a pass over, my lord.
Huh?
Serial number 35.
35.
Yeah.
35, Lord.
35 is not, Mr. Bhagwat, you appears in
Oh,
35.
sorry, Prakash.
35.
Lords,
For urgent.
Lords, I appear for the third respondent, my lord. Lords, I pray for a passover, my lord.
In 35,
In 35,
Lord,
Lords,
that-
respondent.
third
May I
respondent,
make an,
Lokayukta, my lord.
may I make an appeal
Yes.
to your lordship? This is a case where your lordship heard.
Yeah, we remember, we remember.
Kindly pass over, my lord. It was originally assigned to me, my lord.
Pardon?
It was originally assigned to me,
Huh.
my lords. Now my senior colleague, Mr. Arbati, wants to
We'll
appear.
pass over.
Please.
We'll just take it up.
Please,
Pass over, Mr. Bhagwat. We'll
Please.
take it up.
grateful.
My lord has passed over the earlier matter also.
I know you're right. We don't want, we will want to take it up. Once we pass over, then we'll take up passovers.
Yes, grateful.
We'll take it up, Mr. Bhagwat. We'll hear it.
Yes.
Just call the council.
Please.
So 35 pass. 36.
36, pass over, my lord. Prakash.
Instead of
He's
Passover, my lord, I appear for the respondent in this case. May I request 2 days short accommodation instead of Passover?
Pass. My lord, Prakash is just reaching here any moment.
No, I am ready now, but
Because-
Passover, I have some problem in the afternoon. Day after tomorrow.
Where is Mr. Shetty?
He is coming from CAT, my lord. Anytime he's reaching here.
Though a passover is sought by the counsel for the petitioner, comma, so and so who appears for the respondent states on Passover, he shall have difficulty. Re-notify on, just give it to me.
30th September,
Next.
37.
I did appear
Nagaraj.
I will appear for the pension of this.
You are ready?
I'm ready, my lord.
Passover.
It's a small matter.
Time, my lord. Get instructions, my lord, from the department.
What is this?
The only-
Mr. Bhushan, you appear for
Mention,
whom?
my lord. Lord, I appear for the Union of India, my lord.
For promotion.
Please, my lord.
Oh,
Of course, my lord, the answering respondent is the state, my lord.
Yeah, my grievance is against, I was
Against the
placed
state.
under suspension. I'm an IFS officer. I was placed under suspension by an order dated
We'll
21.
hear it, Passover.
Great.
Passover, give the counsel.
38. 38.
For the petitioners, my lord,
Yes.
interim order is there objections need to be filed some.
Against?
Would be taken up tomorrow, minutes. Are you ready in the matter?
You are ready to argue? Ready?
My lord, interim order is in my favor. My lord may post it for argument next date,
Who appears for the
Next.
respondent? Mr.
I am
Amresh?
staying for this.
next week, one date maybe.
No, you appear for whom?
I am for the contesting respondent, applicant before the CAT.
Okay, what is the issue?
Staff car driver, minutes, after 15 years of service, minutes, he is entitled for grade 1. Staff car grade 1 in 4,600 to 7,000 grade pay. Then after introduction of the MACP, he is entitled for the 4,200 grade pay.
How much they gave?
They are still kept me in 2,800 grade. That was my issue.
But is it a promotion post?
It is a promotion.
Are you claiming
It is,
4,000?
there is a scheme, separate scheme for the staff car drivers. Under this scheme, after completion of 15 years, staff car driver grade 2 to grade 1, he is eligible to be promoted. He was eligible, he was promoted, but he was still kept in the 2,800 grade pay only. But however, he is entitled for 4,200 grade pay after introduction of MACP from 1/19/2008.
But MACP, you will get only the next grade pay.
And that grade pay only. After 2,800, 4,200 only the grade.
Is the next grade pay?
Yes, that is the grade.
Then what is the difficulty?
Swami, my lord, the respondent had asked in parity, respondent had gone to the honorable CAT and asked for parity with two other drivers who have joined in a very long back date. There is a 5-year, 6-year gap between the date of joining and the seniority. The parity is asked with those two drivers, and the honorable CAT had given an order in the favor of respondents. Now the question is, the MSCP promotions are taken care by the HQ. This is a regional level promotion that we have given him, and the eligibility concerns have been appraised by the center. Now the central office of the petitioner is also party number 1 in this matter, Swami, and it have been decided on merits. So the question is, the respondent have asked a promotion from 2000 for a backdated promotion for which he is not eligible because he didn't start as a 4-wheeler driver. He started as a 3-wheeler driver. The merits is mentioned in the petition, my lord. I will, if my lord give me a date for argument.
You are ready, we'll hear it. Pass over.
Please.
39, Shri Kumar. 39.
Lord, this is about the grant of the financial upgradation. I think the other side wanted some time. But in a span of 30 years, she was eligible for 3. Our contention is that has been granted.
Let's see the judgment.
It begins at page 16. More is here. Lord, the Lordship take up an item 1. 17,953. Yes, sir. ಇದೆ ಈಗ ಕೊಡ್ತೀರಾ ಅಲ್ಲ ನೀವು ಕೊಡಂದ್ರೆ ಈಗ ಕೊಡಿ ಸೊ ದಟ್ ಅಂಡ್ ಇನ್ನೂ ಸ್ಟಾರ್ಟ್ ಮಾಡಿ ಕೊಡಂದ್ರೆ ಈಗ
What has been granted to them, Mr. Kamath?
Lord, there is a table, my lord, which I have reproduced in the writ petition. At para 9, my lord, page 8, where I have shown
Have been given under MACP 5400.
Yes.
Rate pay of 5400.
Yes, that's it.
Who appears for, you appear for whom?
I appear for all the respondents.
Now tell us one thing, that 5400 is a non-functional grade. But how can you be granted? You appear for the employees, respondent employees.
Yes, yes.
Now, how can you be granted 5400 under the MACP? Now, you gave 4800 is the third financial upgradation.
No, third, it's not third. They were given
second.
6,600, but later on reduced.
Now, what was your claim before the tribunal?
6,600 should be given.
What is equivalent to what? Equivalent to what?
Equivalent, Milla?
Just come to this. 16, page 16, come to page 16.
Lord, is that the case of one Mrs. MC Nanda, my lord?
Yes.
Lord, I have a few authorities which have collected.
So we want to know what has been granted by the tribunal in the final direction. It appears there is some vagueness if you see the direction.
True, my lord.
It is not even a direction. The tribunal says on equality, very good. But what follows? What is the final direction we want to know?
In fact, my lord,
Benefits be made available. What are the benefits to be made available? The tribunal should say, na, these are the benefits to be made available.
in fact, a very similar order was set aside by this honorable court, and with a direction to reconsider and stipulate with clarity what
They
should be
say
the
so.
benefits.
We
Yes,
see the order in that.
I'll print out. here.
My lord, in that,
Highlight.
there was no reasoning by the CIT.
Okay. Where is the reasoning in this order? Show us.
In this, my lord, your lordship may see the order of the tribunal.
Yes, read it. Now see the first line. The matter seems to be covered. They are also, the tribunal is also not clear. Seems to be covered.
Seems to
What
be
is
covered.
this? Is it covered or not covered? Seems to be covered by OA, which we quote. Now the whole quotation till the end, it's only the quotation which runs.
Based on,
And para 3, it says benefits be given. What benefits?
No, that is in that writ petition.
Right?
There, my lord, in fact, I appeared for the respondent in that writ petition also. I told the court that your lordship will not see the reasons in the tribunal's order. Your lordship may send it back to the tribunal.
Very good. What is the reasoning given in this?
My lord, after para 2, their lordships have given reason.
What are the reasons? Mind it. It has not given the reasons. It is only reproduction of an order passed by this court.
precisely.
No, my lord.
Did it? By the Delhi High Court.
Delhi High Court.
95% is reproduction.
Which is this order, Mr. Kamath? This writ petition number of 2018. 9357.
Honorable Delhi High Court, my lord.
That's right.
My lord, I am giving your lordship a compilation where all these orders are put.
What is important, the only objection raised by the response seems to be this, but then it is not relevant. When petition succeed, consequent respondent had to revise the pay fees. Granting third final and another petition, they shall be entered.
Para 3, my lord, is the only reasoning at page 32.
This is based on that FC Jain.
Hold.
Lord, I have just received some material which my learned friend intends to rely upon. Lord, let me go through these.
We'll have it, just show us the judgments.
Yes, my lord, I'll give it to you.
Hmm.
Just take it.
What is the? Proposition rate only. Let's see what else. Let's see what we reach. Favorite copy is the music. Like, because we are placing reliance on that.
Just re-notify these all three matters, no?
Three matters, yes.
Re-notify these petitions. You say this, the learner counsel for the respondents have filed a compilation of judgments in 2 volumes. Okay, the same are taken on record.
I have given my friend
I
also.
Just-
But is your lordship fixing any date, my lord?
We'll fix it.
Sir, 1510.
Memo, my lord. Serial number 13, my lord, has to be tagged along the serial.
15th,
And this appeal would be our hostel.
Yes, my lord, it is same judgment, my lord, and
As I say,
same judgment, my lord, same act.
we just say that in that order, which was that number, Mr. Abhinav?
13, my lord, serial number 13.
Don't say that posted on 2910. We'll do one thing, we'll make it part of that order.
Yes, okay.
So don't say this, just say that this is also connected appeal
Very
arising from the same impugned order.
Very well.
Then we will post it.
Very well.
You're getting the point?
Yes,
Same
I
order,
follow.
this appeal, we'll list it.
Very well.
Next.
Serial number 40.
I appear for respondent in this. Your Honor, matter is covered by decision of this honorable court as well as the honorable apex court. It's been removed without conducting the inquiry, my lords.
These are not applicable to the present facts, my lords. I'll point out. Let's hear.
Was he convicted in this matter?
No, my lords, he was not convicted, my lords. He was absconding, my lords. My lord, it has so happened that a CBI had registered a case, my lords, against the respondent, my lords. Here it. On 2/3/2023, my lords.
We'll hear it.
It has to be heard.
My lords,
And these,
just a small submission, my lords, I was not absconding, my lords. The raid has happened on 3rd and I had voluntarily gone to the CBI authorities and I was arrested on 7th, my lords.
We'll hear it, pass over.
Grateful, my lords.
please.
41. Shri Veerabhadraya.
Yes.
But the appellant's counsel by that permit us to file the synopsis, my lord. And copy is served on the other side now.
Which is the judgment you are relying upon, Mr. Rajgopal?
My lord, I am relying upon one judgment, my lord Ramachandra.
You have also judgments?
No, I have no judgment.
So what he is relying, he is seeking is
Correct.
information with regard to his colleagues.
Correct.
That's right?
My lord, whether those informations which is
81J.
in custody of an institution, whether it is an asset of an institution or it is the property of the person employees. If these two things are understood and it is interpreted, then my lord, the effect of 8 subsection J could be analyzed. This would be the legal issue. That in the another judgment where we have cited, that was a case, my lord, some inquiries have been culminated against an employee. Some information is sought for. Out of those employees, departmental inquiry or domestic inquiry is concerned. Where it is declined and the Supreme Court said it is in the hands of some person, but it is still relating to an individual.
What is the information he has sought?
His information, some other persons have been confirmed. Some other persons have been daily appointed. Their services are confirmed, regularized. Those information he sought for. And seniority of such other persons in the institution he sought for. The authority, original authority said.
No, with regard to everyone working in the institution.
Yes.
I am seeking
The
information
original
only for,
authority said.
Just one minute, yes.
I am seeking information only for unaided employees. I'm not aided, unaided employees. I am working as additional section grant full-time lecturer. My colleagues, not aided. I am seeking information.
Where is your application seeking information? Where is that application?
My lord, page number, my lord, 49. 49. ಮರಿಮಲ್ಲಪ್ಪ ಪದವಿ ಪೂರ್ವ ಕಾಲೇಜ್ ಮೈಸೂರು
This is, my lord, the
2001ರಿಂದ 2021ವರೆಗೆ ಪ್ರತಿ ವರ್ಷವೂ ಅನುದಾನ ರಹಿತ ವಿಭಾಗದಲ್ಲಿ
Which page? Which page?
ಪೇಜ್ ನಂಬರ್ 49 my lord.
Exardi he refers to me.
Is the English translation here?
His translation is. It is not placed on record because, my lord, this petition came to be disposed of by the learned single judge without notice to the institution, my lord. And only they heard the other side, we are not appeared.
Do one thing, you will, both of you, I think Mr. Rajgopal, possibly you have to take this, the briefing council need to take this response, file the English translations.
We will file it, my lord. I'm sorry for inconvenience which we have caused it today. Kindly pardon me, my lord.
Now, and today we are only concerned with respondent number one,
Yes.
your college. Do you think that we require the presence of the university also?
No, not
Pre-university,
necessarily.
pre-university, my 11th and 12th, my lord.
It is his writ petition, my lord.
He is the contesting party
Yes,
and he has sought information from you.
correct.
The Information Commission has granted the information.
Appellate authority said no, original authority said no. Learned Singh just said yes.
First applied authority is success, my first applied authority success.
You file your submissions, we just say this notice issued. Right?
Sir.
The respondent number one is present in person. Full stop. The respondent number one, the contesting party is present in person. Full stop. Appropriate shall be the appellant and the respondent number one shall file the written submissions along with the judgment they want to rely upon. Additionally, the counsel for the appellant shall also file the English translation of the Kannada documents within 4 weeks to re-notify the matter.
My lord, next week, my lord, please, very important, next week, my lord, next week.
We will give you a convenient date, just give it in October.
2310.
Next.
Sorry, my lord.
It's all right.
Translations, sir.
I have to show this. Sorry. No, file a fresh one, Mr. Abhinay, not like this. File a fresh one. Just write it down, give it. You can also do one thing, you can mention it tomorrow also. We can get it tagged along with it.
Serial number 42. Wait for me.
Your Lordship,
First respond.
Your Lordship, in this effect, if I could seek a short accommodation in this,
Yes.
Your Lordship,
Series.
time.
Lord, one submission. There's been a subsequent development where the appellant has now been given posting on 31/8/2024, my lord. I just want to place that on record.
Ma'am, you appear for the appellant.
Yes, yes, Your Lordship. Your Lordship, with regard to the subsequent development, I will have to seek some instructions on that because I am as of now not aware of.
Now, how come you are a party there before the single judge?
Yes.
Hmm. How are you affected by the order?
It's the repatriation order, Your Lordship, that has been challenged.
No, who had challenged it? He is seeking
First-
continuation. That has been challenged, set aside.
First respondent. Because I was the petitioner.
Rupesh MC.
Yes, my lords.
What did he challenge?
My lords, he challenged, my lords, the order of repatriation, my lords, discontinued.
He was on deputation, he wants to go.
Yes, my lords.
That has been set aside.
My lords, that has been set aside.
How is the respondent number 6 is
Initially, my lords, there was a communication, my lords, by which he, my lords, should have been posted to, my lords, to KAD.
in his place?
My lords, that was withdrawn. And, my lords, the withdrawal order, my lords, they did not challenge during the pendency of the writ petition. My lords, that remained, my lords, undisturbed. Later on, my lords, they challenged the main order, my lords, passed in the writ petition. Now, the subsequent development, my lords, is that he has been now given a posting, my lords, elsewhere. My lords, they will have to challenge, my lords, the subsequent order. Otherwise, my lords,
Now, he is also, he wants to come on deputation
come on deputation, my lords, to KADP.
instead of him.
Instead of, my lords, the first
The-
respondent,
The first, the
petitioner,
petitioner.
petitioner.
And what are the subsequent developments which have taken place?
My lords, the subsequent development, my lords, is that
He's been given a posting somewhere else is what?
Desk.
My
So you
concern.
would, if you are happy with that posting, you would not insist.
I will just check with,
The learned counsel for the appellant seeks a short adjournment to take instructions.
yes.
At her request, when do you want?
Any date.
Just give next week.
Twentieth September,
Madam?
ಇಪ್ಪತ್ತು.
Wait.
I was continued, my lords, there was a project from 2021, my lords, I was continuing and that's how, my lords.
Ultimately, the outlook of the employer. That's it. Just take instructions.
If he's okay with taking up that, I think everybody is happy.
Take your instructions.
Yes, please.
Next. And passovers.
Passed over matter, serial number 23, Siddharth Suman. 23,
Senior is held up, is on his legs in a court at the moment. Kindly pass on. The issue was regarding the connected matter in Court Hall 4. That had matter stands over to 25-9 because signatories had not been produced before the court. With a direction to the parties to produce the signatories, the matter has been.
Will pass over.
Yes.
24,
My lord, kindly take it up at 2:30, my lord. I'll go on with the matter. 2:30, please, I'll go.
You want at 2:30?
2:30.
We'll have it pass over.
29. Anish.
Now, what is the position, ma'am?
Your Lordship, we have obtained the order. Senior wants to make one submission, Your Lordship. So it's just on his legs in Court Hall 23.
Do you have the copy of the order with you?
I have the copy of the order.
Just show us.
First paragraph, Your Lordship. The status of the DDR 3 to 8. Also recall coercive orders.
What is the date of this order and what is the next date?
23/8 is the date of the order. Next date is on 23/9.
Just call him.
Okay, but 2:30, Your Lordship.
Yeah,
because
yeah,
he's still
we'll
on
take
his
it up
legs.
after lunch. Just call him.
Yes.
33. Ravishankar.
Let me pass it on.
Pass over.
37.
35. 35.
35, Serum, sorry, 35.
I appear. But I have raised 3 legal questions.
Just 1 minute, Mr. Bhagwat. Mr. Arbati, you have seen The submission is based on the judgment of the division bench of this court. What is being said is the very initiation need to be by Upalok Ayukta or Lok Ayukta, as the case may be. In this case, and that's the submission Mr. Bhagwat is making, that's what the division bench holds. And according to Mr. Bhagwat, these proceedings have been initiated. Initiated means you may say so, but initiation must come from the Lok Ayukta, Upalok Ayukta, not a communication sent by the deputy registrar. And hence it is in violation of the division bench judgment and could not have been done. So he is on the threshold on the very initiation. According to him, if the initiation is bad, the rest of the proceeding gets bad. That's the submission. That's right, Mr. Bhagwat?
Yes, number one. Number two, the entrustment is not done without non-compliance of Karnataka Business Transaction Rule 1977 by the government. Not this.
What, how would, can you just qualify that submission?
Not entrustment order is passed by the government, not complying the Schedule 2, Item 9 of the Karnataka Business Transaction Rules 1977.
What does it say?
It says, my lord, if it's a Group A senior scale officer, the order must be authenticated by the Chief Minister.
But tell us one thing, a proceedings initiated by a Lok Ayukta,
Even by Lokaayukta.
even then also?
Yes. Because Group A senior scale is concerned, it mandates. Number 3, my lord, it is a property dispute. She says in the complaint, her mother executed a gift deed, please cancel it.
No, if we have to understand
Yes.
you, so before the Lok Ayukta initiate, he must send the file to the Chief Minister.
Yes.
Saying that you give your concurrence
Yes.
for us to initiate further.
Yes, my lord. Entrustment.
Interest.
Then, my lord, 8(1)(b) prohibits property dispute to be decided by the Lord Lokaayukta. It's a case, gift deed is taken by my mother. That is, civil dispute is pending.
Okay, let's hear Mr. Abadi. You have heard him. These are the basic challenges. So the submission is, in fact, we were put to him also. Now, once you have submitted to the jurisdiction, why at this stage? The submission is because it goes to the root of the very, cognizance taken or initiation. It can be anytime, something like that, what we sought to be argued. What do you have to say?
But that not regarding the judgment, not with great respect, that what was not brought to their lordship's notice not was section 15. Lordship, section 15 of the Lokaayukta.
You are ready to argue?
Not, I could not if urgency is pleaded. Not, but we have not filed a statement of objections. I could argue, my lord, I could make that preliminary, not just, not, since my lord have raised this fundamental question. And I may have to convince my lords on that because, and I am faced with the judgment of the coordinate bench of this honorable court.
That's right.
So, Lord, from that
If you
perspective,
want to know what is the effect of the judgment,
it's
effect
catastrophic.
of the judgment is that a communication need to be sent by the Lokayukta, Upalokayukta
Yes, ma'am.
themselves?
Yes, my lord, that is. not the-
Although, in fact, we had put it to Mr. Bhagwat, paragraph 2 thereof says upon direction
Yes.
of the Upayukta, Lokayukta, this communication is being sent.
Yes.
It is as good as saying that they have applied their mind, but I am sending it. What is sought to be argued is even the communication must come from them. That's being sought to be argued.
That is what the intent of the judgment also.
That's one. And the second submission, what you have heard. What he's saying is maybe under the allocation of business rules, being a Group A officer, necessary must concurrence be or a sort of a permission be granted for them even to take it further. That's the submission.
That is, government has to answer that question.
Pardon?
Government has to answer
That,
that.
oh, you appear for Lokayukta, that government has to answer.
I'll try to assess. Ma'am.
And possibly you may have to throw light also. Is it the view of Lokayukta also when it comes to a Group A? The state government will also answer.
Yes.
Is it your view that you in all Group A officers take the permission from the Chief Minister, whosoever is the appointing authority, before you initiate the process?
Yes.
That's your also is we want and reply on this.
Not under 12(3), report will be sent to the government. Government under Rule 14A passes an order entrusting the matter to Upalokayukta, Lokayukta. Before, while passing an entrustment order, Lord, it must be authenticated by the Chief Minister. Then government can pass the order. That is what the rule says.
Which is the ground which you have made, Mr. Bhagwat?
Yes,
Which is that ground?
but kindly see that also. Page, that ground is particularly called out, and Lord, I have raised it. My Lord will find page 29 of the pleading. Second legal ground.
Which one, Mr. Bhagwat?
Proposal to refer any complaint or disciplinary matter against an officer or an equivalent officer in Karnataka so and so and so above Lokayukta, Ravarup Lokayukta.
Fine then. So these are the two submissions. Now, would you like to file your response? Both
We
of
will. Lord, we would like to file.
Ah, and then if that is so, because Mr. Bhagwat is pressing for the stay, although that was an understanding, not a part of this, that that final order need not be passed.
Not that is for my learned friend to submit, not only if the threshold not doubt arises in the mind of this honorable court, it is my responsibility not to allay those not any doubts. But the judgment of coordinate bench of this honorable, we will file our statement of objections also. Only regarding the interim order not that is sought. The judgment of coordinate bench of this honorable court, not this will open a Pandora's box. Not we have.
No.
Yes, why I would submit, I'll just not kindly bear with me. Now, this judgment would say that every communication which is sent out from the institution of the Lokayukta has to be signed by the Honorable Lokayukta or the Honorable Lokayukta as the case may be. That is the, that seems to be the conclusion drawn in this, I mean, communications which are statutory in nature. So for example, if a notice has to be sent to any of the DGOs either under 7.1 or 7.2, but it has to go under the signature of the Honorable Lokayukta or Upalokayukta as the case may be. Or a notice which has to be sent under 9.1, 9.2, 9.3 for the compliance of those. And also the 12.3 report or the 12.1 report. But it may not be the purport because the coordinate bench of this honorable court was not, the attention was not
But
drawn.
the only thing is we have to only put it this, Mr. Arbati.
Section, yes.
There is a judgment of the coordinate bench.
Yes.
For
Yes.
us, it's a coordinate.
Yes, yes.
And that's the interpretation which has been given. Has it been taken in appeal and set aside?
Not yet, not my
It holds
instructions.
the field.
Yes,
If it
if
holds
I-
the field,
yes.
is it not binding on us as a coordinate?
But with respect, it may not be for the simple reason, if I am able to point out a relevant provision of the statute, which was not brought to the notice of the coordinate bench, and if your lordships were to consider the relevant provision in the submission that I would make, it may not be as of that.
No, it can. See, then what you are urging is, are you urging it's in per incurium?
But your lordships need not declare it as per incurium. My respectful submission, my understanding of Article 141 per incurium, sub silentio is, your lordship, this would not be binding on my lords if I am able to point out there is section 15, which was
So
not.
then it would be per incurium. See, there is only one argument that is available,
Yes,
possibly, subject to what Mr. Bhagwat says.
yes,
If it is a per incurium, may not be binding.
yes,
If it is not per incurium,
yes,
then as a coordinate bench, either I have to follow
yes.
or refer to a
refer
larger
lord.
bench,
Yes,
or refer to a larger
Yes,
bench.
ma'am.
That's
Yes.
the scope.
yes, ma'am.
Okay. Now, what do you say on this?
That is my respectful submission. It was section 15 was not brought to the notice of.
So it's per incurium, what you say?
But I would not request my lords to declare it per incurium, but since it is per incurium per se, your lordship need not say it is per incurium, so we will not follow. Your lordship could notice section 15 and say that section 15 was not, yes.
No.
I mean, declaration is not required. What I am trying to say is a larger bench could declare the,
Then how can we differ from the coordinate bench?
by referring to section 15. I could say, yes,
Having said so,
yes,
then section 15 was not referred,
yes.
hence it is per incurium?
Yes,
Obviously, per
yes, ma'am,
incurium
yes,
means
ma'am.
that.
Yeah, not for our understanding, it is per incurium. With great respect to the learned coordinate bench, for our understanding, it is per incurium. But a declaration that it is per incurium is not required
Why?
at the hands of my lords.
Why?
Since my understanding, Lord, is per incurium, a judgment to be per incurium, a declaration of that nature will have to be made by a larger bench.
But we want to know, even suppose we have to disagree,
Yes,
either we hold it that is a per incurium, hence not binding,
yes,
that's one.
yes,
If it is not per incurium, it is binding on us.
yes.
If we are differing in the conclusion,
Larger.
don't suppose 15, then we have to refer to larger bench. Yes. That's the position.
Yes.
So then we see that possibly then you have to show us, is
Yes.
it per incurium? This is the consequence.
Yes,
If it is not per incurium, what is the consequence?
very well. I will. That will be my,
That need to be done. Now, you will file your response.
very well.
You will also file your response. How much time you require? Pending that, what is the, protection he is seeking, Mr. Bhagwat? Mr. Bhagwat says that there should not be any final order. Otherwise, it would be a fait accompli. What
Well,
is?
this is all that I could not in relation to objecting to the interim order. But I could take my lords through only one section and show that.
Suppose if finally we comes to a conclusion, let's assume we disagree with him, we agree with Mr. Bhagwat. Let's
Yes.
assume hypothetically.
Yes, yes.
Then it is something, it's a fait accompli. That the order has been passed, it has come into effect.
To some extent, my lord, but there are judgments of the Honorable Apex Court which say that if the foundation goes, superstructure goes.
Oh, obviously, that's right, you are right.
So-
But that is something what you are saying, what he is arguing. He said that if the foundation itself is bad, everything upstairs is bad.
That there cannot be any dispute.
So for how long time you want to file a reply?
But for considering the interim order, my lord, we will file preliminary objections day after tomorrow.
See, to be very frank, for interim and final relief, arguments would be same.
Same.
Argument will be relying upon what he has argued on two things. Otherwise, because since he has raised a pure legal issue which goes to the root, we are considering it. Otherwise, if it was nothing of that sort, possibly we will relegated him to back to the authorities.
Yes. That your lordship also pointed out to my learned senior friends.
So you will file it, but till such time, no final order. Tell us, Mr. Arvati, on a reading of the division bench judgment, forget 15 for a moment. The conclusion drawn by the division bench is this, that even such a communication need to be by a lokayukta, uplokayukta.
Yes, ma'am.
That's right.
That's it.
And in this case, it is not so.
It's not so.
Section 15 has no application. I will come to that. And absolutely no difficulty. Let him read it. I'll answer it.
So how do you say, if you give the assurance before the court that no final order will be passed till the next date, we will not say anything.
Government has to say.
And the government has to say. Yes, what do you say? We will not pass any order, but that's with a clear understanding that you will not pass a final order. Get your instructions, and we want that understanding must be there with a clear view that yes, we will till the next day. Tell us.
2:30 Milad by.
We'll have it at 2:30. Get your instructions, please. We don't want make it part of the order. We will hear it. This needs to be gone into, but you have to give an understanding. It's not that the petition become infructuous.
But according to me, my lord.
Just pass over.
Yes, ma'am. According to me, my lord, if they file reply, both the respondents, my lord can decide the question, one for all.
No, that's right. But obviously we have to hear them also.
Yes, ma'am.
Because that's the reason in fact, that's the reason we wanted to hear the Lok Ayukta's counsel on those. That's the reason. We'll have it at 2:30. Get your instruction.
Great.
I apologize.
Yes.
2:30, I have a personal inconvenience, my lord. I just
Take up that matter.
29. I have very limited submissions, my lord. My lords have heard me on this. My lords had directed us particularly, my lord, to provide the indulgences of the Honorable Tribunal, which occurred on 23/8/2020.
But tell us one thing. Why is this gentleman avoiding?
In fact, my lord, he is not avoiding, my lord. What, my lord, in fact, my lord, today I am not advocating for Mr. Sushil Mantri. My lord, we'll see to that, my lord, he appears there. At the same time, my lord, unconnected persons, my lord, are being summoned.
We are in 226.
I understand this, my
Let's
lord.
be
My lords can pass on any direction to meet the ends of
I
justice.
would not attend, but when it comes to my wife and son, I will file this petition. That we are not able to reconcile.
No, no, my lord, in fact, he has also, my lord, I am instructed to say, he has also maintained a petition before this honorable.
Very well, it's all right. That is pending.
Yes, yes.
When will he appear? Just you show us, we will record your statement, you will appear before the National Commission, file an application for the recall of these two.
In fact, my lord, recall of these two has already been filed, my lord, which has not been considered.
There before the National Commission?
Yes, my lord, which is what my lord present order says.
Sure.
My lords may kindly have this order, my lord, which we have just today placed.
See, the basic, it appears the tenor of the order of the National Commission is.
Yes.
Recording this gentleman is a wife.
I bow down, my lord, I bow down. I bow down, my lord, the spirit of, my lord, the equity has to be maintained. If your lordships would kindly have, my lord, the first page, learned counsel for the JD.
Yes, yes.
Learned counsel for the JD submitted, she has filed an application being IA number so-and-so, seeking deletion of names of 3 to 8, and also recall the coercive orders issued against them. Reply to this application be filed with the learned counsel for the DHS within 2 weeks, by the order dated so-and-so. Non-bailable warrant was issued against Mr. Sushil Mantri to be produced before this commission today. Though the same has been received by the SHO Sabha Kaban Park DCP, Bangalore, but their reports are awaited as per the office report. Mr. Sushil Mantri did not appear in person. Bailable warrants against the 2 other directors of the JD company was issued and they are not present. Though the warrants have been received by the concerned SHO, but the report not yet received. It is noticed that only 137 DHS out of 302 DHS have been paid the principal amount of the decree. Bailable balance DHS have not been paid within a single installment so far. In this execution pay, this is an execution petition of 2022 filed on so-and-so. More than 2 years have passed and the execution applications continues to be unsatisfied and not honored. There is a clear case of persistence, disregard to the decree or order of the commission dated so-and-so, which has been upheld by the Honorable Supreme Court. This commission is left with no option to proceed in coercive manner, for which there is a substantial justification as the number of hearings have been numerous. Registry is directed to issue fresh non-bailable warrant against Mr. Sushil Mantri, the main director of the JD company, to be brought before this commission physically on 23rd September 2024. Registry shall also issue summons to the concerned HS to bring present for being present along with accused number Sushil Mantri for persistent defying of the orders of this commission. Copy of the warrant be sent to both the concerned DCP and also Commissioner of the Police, Bangalore, for execution without fail. Bailable warrants shall continue as already stated against Mrs. Nehal Mantri and Mr. Pratik Mantri. Oh, my lord, my humble submission is, if your lordships would kindly see, my lord, the order at paragraph number 1. Paragraph number 1, my lord, is the order to, my lord, lay response to our application. My lord, in the meanwhile, in spite of the fact that the application needs to be heard, my lord, once again, the bailable warrants against other country, my lord, let the tribunal decide it. Till then, my lord, I may be protected against these bailable
You will
warrants.
do one thing, Mr. Shams. You will serve the respondents. Who are the respondents here?
My lord, there are several in number, my lord, as many as, my lord.
You have their emails?
I am
Send a
afraid, my lord,
communication
but-
on all their emails and one copy to the petition, respondent number 1. We want to have them before us. That's how, then we will see. Because ultimately we can't do it without they being there notifying them.
I understand that, my lord, but my lord, I'm afraid, my lord, if their email IDs are available, because, my lord, we have not mentioned it, it doesn't appear, my lord, in the cause title, both of the tribunal and, my lord, of this petition.
You don't have their email IDs?
I am afraid, my lord, if we have that. Because, my lord, it is a petition filed by them. And, my lord, in the cause title of, my lord, the NCDRC, there is no email IDs forthcoming.
Pardon?
There is the cause title of NCDRC, my lord, National Commission. No email IDs are
Do
forthcoming.
you have the counsel who is appearing for them?
We must be having the details.
Just check up the complaint before the
Yes.
National Commission, his email ID must be there.
Yes. But, my lord, that must suffice, my lord. Let the notice be issued to the counsel who is appearing before, my lord, the tribunal.
And you will also do one thing, just give a copy to at least the respondent number 1 physically. He is based.
One
in
of them, yes, my lord, one of them. With a request to, my lord, keep informed the others. We would do that, my lord.
Keep inform the others.
Yes, with a request to keep informed the others.
Just give the file. Today, Mr. Shyam Sundar and a senior counsel appearing for the petitioner has filed copy of the
order dated 23rd August 2024.
Order dated 23/8/2024 passed by the National Consumer Disputes Redressal Commission at New Delhi. Full stop. The petition has been filed with the following prayers. Full stop. In effect, the petitioner is seeking lay a challenge to the order dated 23/8/2024. Full stop. Appropriate shall be that the respondent orders dated 31/7/24 and 23/8/2024. Full stop. Appropriate shall be that Mr. Shyam Sundar shall send a copy of the writ petition through email to the council who appear through email / WhatsApp.
Email, my lord, his email
he-
ID is appearing, my lord,
Is
Mr.
through
Chandru
email.
Bhattacharya.
Just what is the email?
Sir, it is Mr. My lord, my lord, will just pass it
Yeah,
on.
Mr. Chandrachud Bhattacharya. Just see this
As seen on, my lord, page number 107 of the petition.
email, page 141. Full stop. About the listing of the writ petition and this court adjourning the same to just give a date. Additionally, a physical copy of the writ petition shall also be served on the respondent number 1, namely Mr. Shiv Kumar Krishnamurthy. As we feel that there are around 346 respondents, and it's very difficult. And with 346 respondents, and may not be possible to serve the copy of the same on all the respondents. Full stop. Re-notify. When will you do that?
Kindly grant
Let's
us, my lord, a
count.
couple of
When do you want?
Friday, my lord.
Friday. This Friday? This Friday?
This Friday.
13.
Till then, my lord, this warrants, my lord.
No, till then. You will serve them first.
We will serve them, my lord, but what would happen, my lord, is this is my lord, I'll just plead it and I'll leave it to your lord.
We will have it on Thursday, not an issue. You want Thursday?
It could be, my lord, because, my lord,
Thursday.
what would happen, my lord? I have, my lord, no grievance, my lord. The authorities proceeding against Sushil Mantri, as my lords rightly observed, my lord, there appears to be certain, my lord, observations against
Okay,
him.
we'll have it day after tomorrow.
I think we should be able to do it, my lord. Email communications, we can do it, my lord, right today. My lords may kindly have it day after tomorrow.
Day after.
11/9.
Okay, thank you.
11th, my lord, I am told. Tomorrow, my lord. We will ensure, my lord, they are served today.
Tomorrow.
So grateful, my lord.
Tomorrow.
So grateful.
Serial number 33. My lord, in the afternoon, senior counsel Ravi Shankar is having some difficulty.
A short date.
The short ducks.
33.
Tomorrow.
We'll see, just re-notify 33, just re-notify.
Sixth respond is a bed ridden.
Though a passover was taken in the first round, as the senior counsel is said to be busy in another court, re-notify. Senior counsel for the appellant,
24,
re-notify.
24/9.
The short date.
Achha.
The sixth respond is a bed ridden supreme court palliative attack. A specific date was given today, my lord. Short date.
What is the date given, ma'am?
24/9, sir.
When do you want, tell us? 24/9 is according to us a short date. You want still shorter?
18th.
Just see that. We have to see our diary also. Let's be clear.
I'm sorry.
He doesn't know? Then leave it on 24/9. We'll have it on 24.
Interim order may kindly.
Interim order if I need to continue.
23, serial number 23.
Pardon?
Lord, your lordships may recall, this is the matter, my lord, where there is a mediation.
Yes,
And it
yes.
was before the coordinate bench. The last week, my lord, we had submitted when it came before your lordships. That matter was set down for appearance of parties.
I've highlighted the portion, my lord. The second page. In Comap 509 of 22, Learned Counsel Vignesh Shetty for the appellant has secured service of Learned Senior Counsel Shri D.R. Ravishankar, who is present before the court physically and submits that the appellant is not willing to settle the issues emerged between the parties. In the last line, list these matters on 25/9 for hearing.
It's earlier order. There was an earlier direction for parties to be present.
Now, what remains to be seen, Mr. Naganand?
Lord, what will have to be seen, my lord, is this. The settlement, my lord, encompasses three parties.
No, that's right.
Yeah.
But that, whether that settlement still holds the parties?
That's what is seized off by the lordships. If your lordships will see the penultimate para, what their lordships are noticing, my lord, keeping in view Order 10 inclusive of Section 89 CPC and the civil mediation rules, Senior Counsel for Respondents 1 and 2 and Senior Counsel Appellant be directed to clarify the status of the aforesaid provision by looking into the context in Document 1 produced by Learned Counsel for Respondent 2. In the meanwhile, Uday Kolla, Learned Senior Counsel so-and-so and not is present before the court. Then last paragraph. Learned Senior Counsel so-and-so submits that the signatory, namely Rahul Rana, is not present. Therefore, Learned Senior Counsel Ravi Shankar is directed to keep present Rana in the next date of hearing. But what happened was we filed this memorandum of settlement. In fact, it was sent by the learned mediator to the court to pass an order in terms of it. Now, when that was placed before the court, my lord, the court directed the parties to appear before the court. Because your lordships may recall in that settlement, one of the issues is the settlement of this company petition which is pending in NCLT. This appeal, this writ petition arises from that. And the earlier occasion, Honorable Court had perused that. So what I would submit, my lord, is this. What is now pending before the Honorable Division Bench, my lord, in the coordinate bench is that there is a settlement that is arrived at.
But is the coordinate bench looking into the validity of the settlement?
Yes, my lord, that is the only thing that is left for them to consider now. Our case is that this mediation completes everything. My lord, there were one or two loose ends, my lord. The loose ends, we have placed material before the learned judges there. That's why, my lord, I filed a memo with all these documents. Other side said, no, you can't file it. The Honorable Court said, no, you please address on that question. If mediation sitting proceedings were filed, other side said, no, that is confidential, you can't place it. So the Honorable Court said, we will hear on that also.
What do you say, ma'am?
My lords, on the last date of hearing, we were directed to appear before the coordinate bench and only to record that there is no settlement. We placed the same on record before the coordinate bench as well, and we filed an affidavit before this court. My lords, this is a separate proceeding, my lords. This is an NCLT proceeding. The mediation does not.
Not right, understanding. That's what we have put it. According to him, This settlement encompasses this IBC proceedings also.
Lords, the mediation was subject to the condition that they would pay the entire dues by 31st of March, which they've not.
Right, no, you are not, you are actually right. But the only thing is, what we are just, that's the reason we have put it, whether this issue before the coordinate bench would encompass the settlement also, which includes the present proceeding before us. That's what we have asked him. He says, yes.
Para 4,
My
my lord, of the
understanding is that it
settlement
is listed
refers
for
to that.
hearing
Last time
only.
your lordships perused it. Para 4 of the mediation.
Right, but today, once they say ki we don't want to go in settlement, what remains?
No, what I would submit, my lord, is this, that when parties have appeared in mediation, they have signed the settlement, and the settlement is filed before the coordinate bench with a prayer that please accept it and pass an order in terms of it. That is what the coordinate bench is looking into. So they first directed parties to appear. The bank representative, my lord, authorized person was not there. Some other officer was present. They argued that no, the signatory need not come. Honorable court directed, no, we are directing him to come. So it is at that stage, my lord. If that honorable bench, my lord, were to be pleased to accept the settlement and hold that all the disputes are resolved in terms of it, then, my lord, everything will get closed. But if their lordships hold otherwise, then, my lord, other issues may arise. So that is set down for 25th now, my lord. Because last time they didn't appear.
My lords, the director had appeared. On the next day, Mr. Rahul Rana has been
So
directed
it
to appear.
says set out for hearing. Mr.
Hearing, my lords.
Yeah,
Nowhere it
hearing, my
says for
lord,
mediation.
hearing on this mediation only.
My lords. It says
Because that was
hearing.
what we submitted to the court, my lord. The other side also wanted to hear on the mediation only.
My lords, we were very clear before the coordinate bench that it should be listed for hearing and not on mediation, my lords.
Now they have filed a memo. You have seen that memo?
I've seen, my lord, yes.
That memo says so it's for hearing, no settlement.
My lord, hearing on, my lord, hearing meaning hearing on this memo, my lord. There's no, honorable court has not made any order, my lord, either taking this on record or rejecting the report of the learned mediator. No order is made. We are pressing the honorable court to consider this and pass an appropriate order. So to do that as a precursor, their
But
lordships.
tell us one thing, Mr. Naganan, there is nothing which has come that the settlement, the validity of the settlement will be looked into. Nothing of that sort is said in the order.
Please, my lord.
Show us.
Kindly, my lord, see the order, my lord. Learned senior counsel so-and-so, representing respondent 2, submits a memo with certified documents 1 to 4 and refers section 75 of the Arbitration Act, which reads as confidentiality. Then that section is extracted. Keeping in view order 10, inclusive of 89 of the CPC, senior counsel for appellant is directed to clarify the status of the aforesaid provision for looking into the context in document 1 produced by learned counsel for respondent 2. Document 1 which I produced are the proceedings of the mediation.
Where are you?
My lord,
Respondent number two, produced by the,
my lord, may I read from the top, my lord? It's a very brief order.
who is senior counsel for the appellant?
Mr. Raghavan.
Directed to clarify the status of the aforesaid provision for looking into the context of document number 1. Who is?
My lord, they raised an objection. I produced, my lord, some documents of the mediation proceedings and correspondence. To that, my lord, the other side raised objection. They said the honorable court cannot look into it because it is confidential. On that, my lord, the honorable court pointed out that we need to hear you on this. And for that purpose, they directed the other side to clarify this position. Can we look into that or no? They also filed some documents. So the hearing is limited.
Context or document produced by learned counsel for respondent number 2. That is you.
I produced some documents. And in those documents.
And Mr. Raghavan was appearing for whom?
For the appellant there.
Who appeared for them?
Archbishop. Mr. Raghavan was
Mr.
appearing.
D.R. Ravishankar.
Mr.
appeared for
Ravishankar
us.
appeared.
Okay, now where is your submission noted here?
My lords, I've highlighted the portion.
Second para, my lord, in
Check
Compa
who is present,
509.
Physically submit, the appellant is not willing to settle the emerge between the parties.
So that has been their consistent stand. Here also they say we are not willing to settle. There also they say we are not willing. But the question is, according to us, there is nothing more to be discussed. It is already settled. I have paid them, my lord, entire amount, what was due, my lord, as per the settlement.
No, either See, one thing, their stand is very clear, Mr. Nagaman. Their stand is we don't want to go ahead with the settlement.
True, my lord, the question that falls for consideration in
What is
those.
the effect of signing?
Exactly, my lord. They have signed it and they said that the settlement will cover the NCLT also.
Senior counsel is on his leg before Court of 27, can I request for a pass over?
We'll pass it over. Just call
I'll-
Mr. Ravi Shankar also, but this is, let's see. Okay, pass
It
over.
can be had, my lord, after 25th is not such a long
I
day.
have
to
some
keep-
urgency,
the-
my lords.
It's all right. Let's be very clear. We want the proceedings there have a bearing here. The settlement there has a bearing here, yes or no?
According to us, no, my lord.
Pardon?
There is no settlement.
Very well,
according to us.
that's your way. We'll pass over.
Pass
You are asking, we'll pass.
Twenty-four, Shri B.B. Raju.
Yes.
My lord, petitioner is the owner of the land bearing survey number 61/1 of Tubaralli village, Vartur Hobli, measuring 5 acres and 37 guntas. The said land also includes an extent of 20 guntas of Karab land.
What was the question we posed to you?
My lord, the question my lord posed was two things. Why have I knocked at the doors of this honorable court a trifle late?
No, we say now what is the position status of the proceedings?
It is for, according to me, it is for cross-examination. My friend says it is for statement. It's a stage of evidence. My respect.
313 statement.
313 statement. My respectful submission to my lords is, as the complaint does not make out a case on the face of it, that, my lord, this is.
But that you will work it out there, na?
No, my lord, if there are three things, my lord. As far as jurisdiction is concerned, my lord, pecuniary, territorial, and inherent lack of jurisdiction. These two aspects, pecuniary or territorial jurisdiction, I should take at the initial stage. But if there is inherent lack of jurisdiction.
What is your inherent lack of jurisdiction?
My lord, the complaint itself states that I am the owner of this land. My lord, the Land Grabbing Act is applicable when the definition 2E, D, C are infringed. My lord, under the Karnataka Land Grabbing Act, land is defined as government land. Under the AP Act, it includes even private land. In our state, it is government land. I will, my lord, may kindly take page 71, the complaint.
But did you take this point earlier also?
Pardon me?
Did you file any objections to the complaint earlier for the court to look into it?
My lord,
Tell us what is the process? Process is once the cognizance is taken, you are entitled to file objections?
Yes.
Did you file objections?
Not yet, my lord. Before, I'll come one step before that, my lord. The act mandates that, first of all, the complaint should prima facie make out a case that it is a case of land grabbing. Namely, one, that it is government land, and what are the relevant particulars. Only then it should enable the authority to examine whether it is a government land and therefore issue notice. That is the mandate of law. My lord, way back in 2009, the Supreme Court said in
But you didn't file any objections?
No, my lord, I don't think any objections have been filed.
challenged that cognizance order.
They have not challenged that cognizance, only to quash the proceedings they have challenged. They have not filed any objections before the.
What do you say?
My lord,
Just 1 minute, listen to us first. He says it is your case that this is a land owned by him. Is it your case which you have set up?
no, your. The case is that in that survey number 61/1, it has 20 guntas of Karab that is classified as B Karab, which has been illegally occupied and encroached by the petitioner.
Where does your complaint say so?
I have said, your honor. In fact, I have stated in my statement of objections also.
Five. My lord may kindly permit me. My lord,
Just 1 minute.
Yeah,
Please,
I'm
one at a
sorry,
time,
sorry.
we'll hear you.
oh, please, sorry, my, sorry.
A copy, please.
Now come to your complaint. Annexure F is your complaint,
Yes, sir.
Yeah, page number 71.
page 71. Where do you say
I've got it.
public land, Kharab land measuring 20 guntas, obstructing public road, right of way? Where do you say that he is the owner?
First parameter.
Huh. And how much is occupied?
20 guntas.
guntas of government land.
Then why do you say so? They is the owner? See your first line. The applicant submit respondent is the owner of property.
Look, the RTC extract in the name of respondent is. That is survey number 61/1. Respondent name is reflected in the RTC, but in the RTC it shows as 20 guntas as B Karab. That doesn't mean that that entire 20 guntas belongs to the respondent only. Wherein they have in the year 2014, my lord, they have converted the land from agriculture to non-agriculture purpose. In that conversion copy, there is a specific condition imposed by the DC, which they themselves have produced before this honorable court, your honor. That is at page number.
Now see the schedule to this.
Yes, my lord.
See the schedule of the property.
East.
You see, he says his name is 16. The respondent should be, but here also says submit legally. So are you saying that he is not owning any of the land?
Yes, my lord, it absolutely belongs to the government. B Karab.
How much? The 20 guntas?
Yes, your honor.
How much he is occupying his own land?
1 acre, 8 guntas, 33 guntas he is occupying.
Total.
Total.
How much is his?
33 guntas is his property. Remaining is 20 guntas is entire.
So is it 33 plus 20 is complete? How much is the complete land which he is occupying?
That is 5 acre, 37 guntas is the total extent of the land here. In that one, that is Anil Kumar has been owning 4 acres, 8 guntas of land. This petitioner who is before this honorable court owns 24 and 0.4 guntas, and his cousins Geeta and Co are 24.4 guntas. Totally 1 acre, 8 guntas is the land they are owning, your honor. That 1 acre, 8 guntas land has been converted for non-agriculture purpose, Your Honor. If Your Honor kindly see the document which they have produced at annexure conversion copy, my lord.
So this, as per you, scheduled property 20 guntas is being occupied
Yes, Your Honor.
out of total area of,
1 acre, 8 guntas.
show us this.
I will show you, Your Honor.
You say 5 acres, you say 1 acre. How much
For
is?
remaining 4 acres, 8 guntas.
Show us that. We'll
The
come to you,
RTC
we'll come
is-
to you, we'll hear you.
Please, ma'am.
Which page?
Kindly take a statement of objection filed by the state, Your Lordship.
Huh.
There you will get, Your Lordship.
Where do, which page is that?
Page number 7, Your Lordship. Is the RTC extract? Statement of objections.
Where is statement of objections? Ma'am? Where are the statements of objections?
They have not filed. You have not filed statement of objection. State has not filed, ma'am. Only the contest, the complainant has filed. Leave killer.
Where is your, this thing?
It's filed, Your Lordship. That I have a copy.
When did you file it?
No, filed at 3/9.
Have you got a copy of it?
No, madam, I don't.
Yeah, show us, give him a copy also.
I'll send it.
Yeah, show us. Who is the complainant? Who are you?
He is the complainant. He is the complainant.
What is the locus?
It's in Bandadari, which has been obstructed by the petitioner, wherein general public are suffering without using that Bandadari, Your Honor. As it is classified as a cart track in the revenue documents and in survey records, he has been illegally occupied and encroached and is obstructing the general public to use that cart road, Your Honor.
An RTC. Shows the 24 guntas and so on.
You file English translation, give them a copy.
I'll serve a copy of this.
Just say this objection stated to have been filed by whom, who are you appearing for?
For the state. R
R,
R3.
R.
R
two,
R2,
three,
3.
2, 3, 4. Has filed objections. Which are the same are not on record on 3/9/2004. The same is not on record. Let the same be brought on record. Let the same, a copy thereof, be given to the council appearing for the
Copy, sir.
petitioner.
I have served the copy now, right?
He has given a copy of the same to the council for the petition
As well as the complainant.
and to the respondent number 5,
Five.
who may file a rejoinder to the same.
This morning I had filed additional grounds, might kindly be taken on record. I'll file a comprehensive,
Additional ground, you do it in your rejoinder.
please, I'll do that.
Be filed within how much time?
10 days, please.
2 weeks. Re-notify on. You know, you file the council shall also file, the council for the 235 shall also file English translation of the Kannada documents. You want to file any rejoinder to that?
I'll file.
Full stop. The liberty is granted to respondent number 5 to file a response. No, that would be no, just say that, just cut it off.
Court of
71, 71.
Complaint cop page number 71.
File it, date, just give a date.
Please, Malad.
Given the date?
That's 15.
Please.
35, November 35.
Yes.
Of now, Malad, it is Malad department. That to be sent to the Malad department. Meter for Malad. Of now, it is in the department. In a week, Malad, I will file objection.
But till that time, don't take any precipitated steps. We are not making part of the order. What do you say, Mr. Arbati?
Also, my request, not to supplement what my learned friend said, that this matter would not open a Pandora's box because no communication in relation to 911.
We will decide it, Mr. Arbati, we will decide it.
That's why I'm not. I would request.
Tell us very well, we are ready to hear you.
Not,
But the only thing is, how would you answer that coordinate bench judgment?
yes, ma'am. That about skirting the not using the right word, bordering the per incurium aspect in relation to section 15.
Yeah, otherwise, very well. So will you file it when, how much time you will file it?
We'll try to file it day after tomorrow, Your
That-
Lordship may have it on Tuesday.
Yeah, we'll hear it. We have no issue. How much time he will seek?
Within a week, Malad, I will file.
He said week's time. You say day after tomorrow, between both of you. Very well,
4 days, Malad.
very well. We'll have it 4 days. We'll have it on next Monday, not an issue.
Yes.
Please, Monday.
Before that, we'll file it, Lord.
Give me a copy.
Copy also.
But till that time, we have it that you will not pass any order.
Malad, as of now, Malad, it is in the department.
So what are your instruction? We want to know. We want, what is your stand? We don't want to put words. Tell us.
Till 18th, Malad.
Very well. So that's the understanding. So we will have it Monday. Okay?
Monday and Tuesday, I see Monday is red and Tuesday is. green.
Monday. Monday is red.
Monday is
That's
red,
right.
Lord, and
Yeah, you're
Tuesday
right.
is green.
Just say this, Mr. Arbati appears for.
Your Lordship, indulge me not to say both,
Oh, yes. So and so appears for respondent number 3.
yes, both of us,
Just take both of them. Mr. Arbati and Mr.
Haladi.
Haladi. Mr. Haladi appears for respondent number 3. Stop. The council and so appears for respondent number 1, 3, 1 and 2. He appears for
One only.
Mahanagarpalika also, no?
No, Lord. For that, my Lord, Mr.
Sanjeev will
BS
appear.
Srinivas.
Mr. B.L. Sanjeev.
Srinivas had
He was there in the
he was-
morning.
yes,
the
he was here.
council. So and so appears for respondent number 2. Okay. Just Mr. Arbati and so seeks and allowed 4 days to file reply to the petition or affidavit to the petition. Full stop. With a copy to the learner council appearing for the petitioner, who may file a rejoinder within 1 day thereafter. Okay?
1 day probably.
You tell us.
Give me 3 days.
Lord,
On
we'll
a
serve before
on or before Monday, we'll say this, the counsel for the petitioner shall be at liberty to bring the rejoinder to the court on the next date of hearing by serving an advance copy of the rejoinder on the counsel for the respondents. That would be fine.
I'll ask him.
List on Tuesday.
79.
Okay.
change it to counter now, because affidavit has different connotation. We file affidavit generally when your lordship.
My lord,
Generally, writ petition, we say counter affidavit, but we will say so reply.
Yes, yes, please. Great.
79.
Tuesday,
entry model maybe, my lord.
he is giving an assurance.
That may be recorded, my lord, because for some time, my lord, the communication gap, I'll be left with no.
Take that assurance, Mr. Bhagwat.
Aye.
We are taking your assurance.
Instructions, my lord. With instructions, my lord, I submit.
That's right. With instructions, he is submitting, Mr. Bhagwat.
Yes, my lord.
We take that assurance.
Yes, yes. It's enough. It's enough.
18th, 18th,
70.
17th. Next.
37, Shri Nagarajan.
Petition. My lord, by the order.
Yes.
Yes, my lord, please. Not by the order dated 21 June 2023, while annexed year 14, lord, page number 119, page number 119, I was placed under suspension. I'm Indian Forest Service officer, my lord, please. Now, my lord,
Yes, morning, I sought my lord. Instructions are squared.
We'll just see it. Now, what does the tribunal holds?
Tribunal says not that petition is by petition dismissed that.
Let's see the order.
Lost my kindly page number 284. The operative portion may permit it. Keeping the above facts in view, the present OA being perfect of any merit without be also dismissed. However,
284.
it-
248.
Sorry, it's 284.
page, operative portion.
Operative portion, that's.
Page number 284.
284 is different. 284.
Ink page 2.
Yes.
Internal page 37 of the improved law, ink page number 284. Keeping the above facts in present OA is being perfect of any merit whatsoever dismissed. However, the following observations. The order of interim stay stay against the suspension of the applicant by the Honorable High Court of Karnataka will only till the pendency of the present applications. Since the present OA has been dismissed, the interim stay against the suspension order by the Honorable High Court ceases to be inoperative. Keeping in view of the provisions of Rule 3 of AIS Dispute Rule 1969,
and the fact that a detailed charge memo has been served on the applicant on 21/3/2024. The state government is empowered under these rules to place the applicant under suspension.
Why were you suspended?
I, Lord,
Why were
I
you
was
suspended?
I was suspended on the ground some illegal, I did not notify the felling of the trees and all on that ground, my lord. No, my lord, I filed a memo of the rules, my lord, with the, on 18/7/2027. Your lord may kindly refer to the rule.
Has the new charge sheet been issued?
No, till now, as on today, your
When were you suspended?
charge sheet has been issued on 21/3/2024.
When were you suspended?
21/6/2023.
Now charge sheet issued?
No charge sheet issued.
Now, what is the reasoning given by the tribunal?
The reason given by the tribunal is that Lord said the initially placed reliance upon judgment of the Honorable Supreme Court of RP Nayak case for the purpose of desirability of keeping our All India service on suspension. Necessarily, there shall be a charge memorandum that was not issued as on that date. Besides that, the court, the tribunal goes contrary to the full constitution bench of judgment. No, even contemplation itself is sufficient.
So let's not go into that.
Yes, ma'am.
Contemplation, no contemplation,
Yes,
pending
yes, ma'am.
departmental
Yes.
inquiry, they can do it.
Yes, ma'am. Yes, ma'am.
Now a charge sheet has been issued. Now
Yes.
what is the stage of the proceedings? What is the stage of the departmental proceedings?
I've been asked to, the charge memorandum asked to submit statement of objection. I filed it.
You have filed it.
I filed my statement of objection.
No, Milord, he is working, the work of the interim order granted, which is done before the application. That he is working on.
He is working.
Not in the place
No.
where Milord is.
No,
Sorry.
only one submission, ma'am. Only one submission, ma'am. No, one submission, ma'am. I don't dispute.
He has been now working,
He has been working. Yes.
then fine. What else you want?
No, but now the tribunal order, not that. Tribunal order has been, I've been placed under, I initially approached the tribunal, they declined to grant interim order. I approached this honorable court. This honorable court stayed the operation of the suspension order. Again, with liberty, writ petition disposed of, I went and approached that. He said the writ petition, the application is disposed, original application is dismissed. Now he says that, by the tribunal further says that, makes it clarifies, in view of the fact that the Honorable High Court has granted only the interim order only ceases to be in operation, it is dismissed, therefore it revives.
What revives?
Suspension order, Lord may kindly see that.
You say you have been given appointment.
I was not disturbed, but anyway, but this honorable court has stayed in the tribunal order. Therefore, I am working. This present impugned order passed by the tribunal has been stayed that by the order dated.
What is the position, Mr. Bhushan? Now it appears what is there is, when he comes to this court, it was stayed.
Please,
And on the strength of that stay order, is he continuing?
please,
Or
my
is it a
instructions,
fresh order passed?
no, my lord, my instructions are that, my lord, that he is continuing.
I'm
Okay.
continuing, I'm not
Continuing,
disputing.
there's no
I'm-
doubt about. Your lordship, for a moment, kindly look into page 285. See, last paragraph, my lord. Of course, my lord, I have very limited to say in this matter, my lord,
Yeah,
but
you are
for
not the authority.
please, my lord, kindly see the last column number C, my lord. The respondents, may I read it out, my lord? The respondents are directed to ensure that there is an expeditious inquiry in the present case in furtherance to the charge memo dated 21/3/2024 issued to the applicant. And the proceedings are brought to the logical conclusion within the time frame not exceeding 12 weeks from the date of receipt of the order. My lord, the authorities have to conclude it, my lord. The reason is this, my lord, why the tribunal has passed such an order is at page, next page, my lord, 286. Taking into the consideration of the seriousness of the matter, my lord, the
286.
Please, my lord, that is in page 38D, my lord. The respondents further directed to take immediate further necessary action as required under the law on the report. If any submitted by the SIT set up wide under dated 11/1/2024.
No, 1 minute, Mr. Bhushan, we don't have that.
The last page.
Last page, not page, last page of the impugned order, last page of writ petition.
Okay, last page of the,
Writ petition, the memorandum of writ petition.
see, we have the page, last page.
285, not hundred.
After 285, we have Wakalatnama.
Only 285, only my friend reads.
My lord, in my paper book, my lord, it is page 268, in page 38, my lord. In page 30,
Read it.
in page 38, my lord. The respondent of further direct, my lord, got it, my lord? The respondent further directed to take immediate further necessary action as required under the law on the report. If any submitted by the SIT set up wide under wide order dated so and so, issued by so and so. The SIT wide order dated so and so has been directed to submit a report by 11/1/2024 after investigation into the alleged similar irregularities in 71 other cases of illegal felling of trees in Virajpet division in the last 3 years. The State Forest Department shall prepare a detailed action taken report in the matter within 2 weeks from the date of receipt of the certified copy of the order on the report of SIT received by them for consideration of the respondent number 2, Chief Secretary, who shall issue appropriate direction in the matter for. My lord, this is a rampant felling of trees in the forest, my lord. Therefore, my lord, taking to the action, my lord, your lordship may also direct the respondent to take immediate action, my lord, as directed by the
Tribunal.
Please, my lord.
So the reason is only this. And ultimately, they have dismissed, however, with the following observations.
No. No matter whether the question.
Ceases to be operative. Once is, yes.
The one submission not.
Any order passed in this court, by this court in this petition?
Lord, I'm not in this petition, my lord, to my
Not in-
knowledge.
Stay, na?
No.
It's statement, please do.
Very
My
big order.
knowledge, I don't know. my lord.
If not the order
Just show me
dated
the-
28 June 2024.
Yes, now what do you say?
No, you ask me now whether the tribunal can, the question is that whether the tribunal can dismiss my suspension order in spite of the fact that the charge memo has been issued after 1 year.
Right, you will work it out. They have also said so that inquiry will be completed Saturday.
No, one submission, that time, whether the tribunal can, what was, what was the matter, what the tribunal was sitting upon judicial review of the order of suspension dated 21/6/2023. That was the, whether can it go beyond the pleadings and what, is it their case, is it my case? You will also make clearly refer to the impugned order, the date on which the suspension order, the order was reserved. The petition was reserved for orders. That is, you will also make page number 248 of the in page 248. Order reserved on 19/3/24. Date of order 23/4/2024. I'm not on that one. Now, the charge memo has been filed after reserving the matter before, after reserving the matter order, without notice to me, it was served on before the tribunal. A memo was filed before the tribunal. On that basis, without giving me an opportunity to me, when the disciplinary authority is asking that why, look into file your statement of objection, statements for that, the tribunal has on its own come to the conclusion without giving an opportunity and hearing me, without listing a matter for hearing on that point, charges are serious. Whether charges are serious, I may not entitled for at least before the tribunal, before making such an observation, I may not entitled to an opportunity, my lord, please.
Yeah, right.
Therefore, my humble
Forget the charge sheet has been issued. Everything.
Yes,
Now
yes.
you come on suspension.
Some
Come on suspension.
suspension,
What is wrong?
you will ask me, the suspension order is dated 21/6/2023. I produced the rule, All India Discipline and Appeal Rules, not the 18/7/2024. It is available. I produced a copy of that rule, not this copy of the rule was also made available before the tribunal. Ignoring that, anyway, you will ask me kindly refer to the rule. Copy. Rule 3, A, B, C, second proviso. ABC second proviso. Remember, provided that where a state government passes an order placing under suspension a member of service against whom disciplinary proceedings are contemplated, such an order shall not be valid unless before the expiry period of 3 years, period of 30 days from the date from which the member is placed under suspension, or further period not exceeding 30 days as may be specified by central government for reasons to be recorded in writing, either disciplinary proceedings are initiated against him or the order of suspension is confirmed by central government. The disciplinary proceedings were admitted it was placed.
Did you plead this point before?
Yes, ma'am. Yes, ma'am. I said.
What does which page?
Where before this tribunal, before this honorable court,
Before the tribunal.
before the tribunal, not that.
Did you plead this point before the tribunal?
Before the tribunal, not that initially I placed reliance upon the fact that the it shall be necessary to place him under.
Yes. No, wait, did you plead this? This you have not pleaded.
Though it is not specifically blood, I placed the rule before the tribunal and pointed out, now the period has been, that has not been referred to at all.
Stand of the central government?
Lord, this stand of the central government, my lord, as of now, my lord, I have nothing against the order.
No, but here your role comes, Mr. Bhushan, in proviso 2.
My lord, for that, my lord, if I draw your lordship's attention to para number 26, my lord, of in page 35, my lord. In page 35, my lord, of the order, my lord, in page 30, para 26.
Impugned.
May I read it out?
Yeah.
About, however, plain reading of rule 3 of subsection 1 indicates that two separate scenarios are envisaged under the rule. In the first scenario, the rules specify that having regard to the circumstances of any case where the competent authority is satisfied that it is necessary or desirable to place under suspension a member of service, it can place him under suspension. In the second scenario, where articles of charges have been drawn up and having regard to the nature of the charges, where the competent authority is satisfied it is necessary or desirable to place suspension a member of service, it can place under suspension. The only other condition prescribed with regard to the suspension is that where a state government passes an order placing under suspension a member of service against whom disciplinary proceedings are contemplated, such an order shall not be valid unless before the expiry of period of 30 days from the date from which the member is placed under suspension, or such further period not exceeding 30 days as may be specified by the central government for reason to be recorded in writing. Either disciplinary proceedings are initiated against him or the order of the suspension is confirmed by the central government. This is the Lord, may I draw your lordship's attention for page 32, my lord. The reason of the delay is explained there in my lord. It starts from para 19 of page 32, my lord, in page 32.
This order is not passed by you.
I totally understand. I'm just only assisting. I'm not opposing.
Thank you, thank you.
Yes.
Please.
No, Lord, the finding of.
Let him complete. Yeah, para page 19.
Page 32, para 19. The allegations of illegal felling of trees. Your lordship got it, my lord? Illegal felling of trees investigated by the additional principal chief conservator of forest. He has submitted his report on 4/2/2023. However, the state government did not issue any charge sheet in the matter till 21/3/2024 and after a lapse of 1 year. Moreover, in this report, so and so has specifically mentioned that there was a possibility of these types of cases happening in the last 3 years in Virajpet. Hence, it has been recommended to inquire into the order of issued of cutting of trees to the initiate disciplinary action against all those officers who have directly or indirectly involved in and cooperated in the illegal tree cutting. It is observed that the forest department continued to drag its feet even after receiving such alarming reports alleging large scale of irregularities involving cutting of trees. The forest department has belatedly set up a special investigation team on so and so for about 1 year from the date of report of the so and so vigilance. These unexplained delay, that's the next para, these unexplained delay in taking suitable action by the state government and the forest department give an extremely poor reflection on their functioning. Such sand report to wanton duty to protect the forest and prevent environmental degradation in such eco-sensitive zone needs to be strongly depicted. This the only this thing, blood. The tribunal has looked into all these aspects of irregularities.
Only one submission, Lords. I I have to bow down the public split of the tribunal. Whether it has jurisdiction going to the matter. That is the question to be liquidated. What is the is it a public interest litigation? Am I given at least an opportunity before after reserving the matter for orders? And your notice was 21-3, they filed that they filed a memo. Based on that, they went on making that comment. Am I not entitled that?
All right, don't get into that. They have filed it, the tribunal has taken it.
Yes, ma'am. Whether the tribunal has jurisdiction without giving an opportunity, taking it into public interest litigation.
Let's assume those observations are not called for.
Yes, yes.
But on a substantive issue of suspension, with this kind of a serious charges, how would you justify it?
No, but my justification, if the articles of charges are not served, now you are not. Days for remove. What is the rule says? The rule is not valid until. No, before the rule was amended somewhere 2015, but before that, the Honorable Supreme Court is interpreting Art 3(1), the Constitution, when the Supreme Court says that before placing an All India Service Officer into suspension, necessarily there shall be articles of charges.
You did not apply your mind on they did not send you.
That.
That is what he is, laying stress on a pure law.
The rule says.
But the fact remains today there is a charge sheet.
That I admit, I have submitted my statement of objection to charge memorandum.
Now we are putting it to you. This you must answer. The intent of this proviso.
Yes, ma'am.
Is that either the central government will apply mine, or if there is an issuance of charge sheet, then suspension becomes valid.
No, that is once your second proviso, your lordship kindly second proviso C. Second, once the state government, if the state government places me under suspension,
right,
you should have issued the charge sheet within charge memorandum within 30 days from date of order of suspension. Another 30 days is given to my learned friend, not exceeding 30 days. He should have also confirmed that within 30 days. Neither charge within 30 days, neither central government nor state government, that is banned. So the rule says that shall not be varied. In suspension order shall not be varied.
Yes, Mr. Bhushan, what are you saying? Look out now, you are right. It's only when they act, you have to act. You're right. We are surprised why they have not forwarded.
Lord, I shall not comment upon that. The charge sheet, charge memorandum also kept to be issued by the inspector of oral instruction.
We are putting it to you.
Please, madam.
If the state government doesn't forward, can this proviso come into play?
So far as himself is not come, so far as himself is not confirmed it. The 30 days time is given to state government. And if it is not done, it can, for reason to be recorded, another 30 days is available to central government.
Provided they get it. The
Yes,
30 days runs
settled.
after they get from there.
Yes, I can't find fault with
They
this.
don't get it.
I can't find fault
We
with
are
this.
putting it to you.
Please, madam.
If they don't get, central government doesn't get it, the 30 days against central government will not run. The 30 days against central government will not run. They'll start 30 days would running when they get from the state government.
30 days. And they did not do that much. They did not do around 1 year. The tribunal also mentioned in this order only.
What if they will forward it and you will look into it? That's all.
No, that that is not that.
Why not? How will this 30 days against central government starts running when they have not sent it?
And they have no occasion to act. I don't dispute that fact, madam. The question is that.
We are putting it to you. That proposition based on proviso 2 against central government would not come into play till such time the state government sends it.
But can it be done with that
Suppose central government says.
it was not pleaded by the central government, the tribunal, that was not done. They did not say so.
You tell us whether the central government whether they have sent it to the central government and central government did
No,
not
central
act.
government at this stage, not that the state government can having issued the charge memorandum. Now what is I've been shifted out of the place. I've been shifted out of the place also. Originally at the time of situation, I was at Virajpet, then subsequently transferred. I'm working at Bangalore, Aranya Bhavan. Right now. Is it at this stage not, does it require not to a direction of the central government, state government to this?
Right, even the spirit of this is, if they have been initiated, then it is proceedings are initiated against him or the order of suspension is confirmed by the. So the issuance of charge sheet is itself justifies the suspension. See, if you see this period not awarding 30 days as may be specified by the central government for reasons to be recorded in writing, either disciplinary proceedings are initiated against him or the order of suspension is confirmed by the central government. Central government did not confirm here, but the proceedings have been initiated. According to him, these proceedings need to be initiated 30 days, within 13 days, and a further 30 days by the central.
The rule. No. Whether such a direct, whether it is whose case, what the tribunal was sitting upon judicial review of the order of suspension.
whether it has jurisdiction without giving an opportunity to me to go into beyond that, is it a logical conclusion? Is it a public interest litigation or not that? They
He'll-
cannot, though the tribunal.
The state government, why didn't they send it to the central government?
Swami? No. No, my lord, even that central government 30 days also, that time limit what has been available, that has also gone. That has also gone. Now my friend cannot do that, go against the rule.
That's right, you're right. Without the state government sending, even now the central government is precluded.
It is precluded, my lord. That also for reason to be recorded in writing. So there are two ingredients. One is the 30 days, another for reason to be recorded.
We will interpret this proviso.
In plain language, it's not, it's unambiguous, very clean, not please that, clear.
Okay, tell us.
No, my lord. Therefore, my lord, you know the fact that the order of the tribunal is contrary to the proviso to that, my lord, that neither the state government has acted upon, because no doubt not that the second central government cannot be faulted upon, that 30 days as time is given. So if the order of the tribunal.
Mr. Bhushan, is your stand? They have not sent it to you. I don't think in this. Two 26, we should not. And if we want an interpretation of proviso, we will give an interpretation that 30 days on the central government would run only when they receive from there. How would they know that the gentleman has been suspended? The 30 days would only run once that has been received by the central government. In between, any proceedings initiated, that would confirm it. Who issues the charge sheet?
Charge sheet is by state government.
I don't think we should interfere in this. See, we want to know. See, why we are saying, let's assume, forget this case. He has raised an issue. He has raised an issue. Let's assume for a moment the state government doesn't send it to you. Then whether those 30 days starts running against you, you are not in the knowledge. You would only get knowledge once they send it to you, then you act within 30 days. The proviso says 30 days is the upper limit within which you must confirm. Alternatively, either disciplinary proceedings are initiated against the officer or the order of suspension confirmed by the central government. So two eventualities, but within 30 days. Let's assume for a moment today you have not received it. The 30 days would not run against you.
Please.
Suppose they send it today.
30 days.
Or we will add. Now today there is a charge sheet issued. Has been issued to you.
Finish.
So there is no need for you to confirm it because charge sheet has been issued. See, either disciplinary proceedings are initiated against him, okay, or the order of suspension is confirmed by the central government. So there is no charge sheet, but within 30 days you have to confirm when there is no charge sheet. But when there is a charge sheet, the case has not been received by you, they have issued charge sheet, whether this proviso actually come into play.
Well, the 30, now as on today, because of 30 days, they did not kept they cannot pay, they cannot send it back, send it not that. The outer limit available to the central government is only 30 days, not that.
No, we want to know.
30 days for them, addition to 30 days.
Yeah, we are putting it to you. You must answer this.
Please.
30 days for the state government.
Yes, ma'am. Yes,
Okay.
ma'am. Yes,
30 days for the central government.
Yes,
provided the state government sent to the central government.
that is not stated here, not that is it.
May not be. How would the central government act?
They can't act, they can't.
Unless they get a,
Yes, ma'am, there must be knowledge on that.
now, keep this scenario in your mind. Now read the proviso.
Yes, ma'am.
Mr. Nagarajan, you got it?
Yes,
Now
ma'am.
what we are reading is,
Yes, ma'am.
let's read the complete proviso.
Yes, provided also that where a state government passes an order placing under suspension a member of the service against whom disciplinary proceedings are contemplated.
Now, just wait for a moment. So there is a suspension order passed.
Pass.
This limb has been fulfilled.
Full contemplation, they have done it.
Now
Yes.
read further.
Such an order shall not be valid unless before the expiry of that period of 30 days from the date from which the member is placed under suspension. So that has not been done, roughly. Or such further period not exceeding 30 days. The outer limit is prescribed for central not exceeding 30 days, as may be specified by the central government. That must be specified by the central government, must be 30 days. For reason to be recorded in writing, either disciplinary proceedings are initiated against him or the order of suspension is confirmed by central government. Now, what is the latter portion of this model, that the order of suspension must be confirmed by central government. Or disciplinary proceeding must be done within either of these two. Either of these two is not done, not that, the order of suspension has to go as per the rule. And this rule, the tribunal specifically quotes, in spite of that petition is dismissed. Very unpartial, not that thing.
But how would you answer the charges?
Charge, that is not the matter before the tribunal. Now you will also be.
You're right. Forget it. You're right.
That is just a separate proceeding, not the state government has directed me to file your statement of objection to charge memorandum and submit that. That is under process. That is a separate course, not that. That is a separate course.
May make one submission. First, my lord, let my learned friend think that I'm not opposing him, my lord, as a matter of fact, my lord, as an officer of the court. My lord, the suspension does not come into act now because he's already working. It's only an inquiry to go on.
No, I'm not on that.
That's one point. The second point is this, my lord. This guidelines or lot 3(1) would come into effect if the charges are not framed and lot here in this case charges are framed, charge sheet is already filed. So therefore, my lord, my humble submission would be, my lord, at this point of time, Lord, the state sending it and the central government giving the approval.
See, these are 30 days. that first 30 days for the state government is issue a charge sheet. Second 30 days for the central government to confirm the suspension. These are the two eventualities. Say nothing has been done. You can say you did not get the information. You could not confirm it. But neither they have issued charge sheet within 30 days. That is also another issue. But the only thing is, what his submission is that in the facts, today even this central government is precluded, even the state government is precluded. But what observation you have made in the first that he has been now working? That working is on the strength of the first stay order given by this court.
Yes, madam. I from the term.
And the status quo order passed by this court. So on the basis of that first stay order, he is continuing wherever he was working. And there is a status quo given by this court. But the tribunal dismissed the petition with certain observations.
No, sir.
But ultimately, the net conclusion of the tribunal's order is dismissed. So now we have. We will reserve. We will consider, we will reserve. Thank you.
Great.
Reserve.
Thank you, Lord. The grateful Lord, only thing is I'm relying upon this, Lord, that your Lordship, even before that, Lord, your Lordship knows about the judgment, a constitution bench of judgment which is interpreting the rule. What is the intention of the rules, Lord, that will be the
Technical.
RP Naik versus Union of India, referring to All India Service rules, Lord, that please. And but the above all, the tribunal went on, issue charge sheet, issue overall, orally, not issue charge sheet, issue charge sheet. At the instance of that, I don't know what happened. Anyway, I'm not that, I'm telling, broad is not. Your Lordship kindly see that the order is, what is the date on which the order was reserved? Under CST procedure. Please. Here, under CST procedure rules, you are also well aware, within 18 days having reserved that order has to be pronounced under procedure rules. So sometimes it happens not. I do agree with that. You have, but see that's great, much great.
Number 40, to promote. Sir, sir. Yes. Sir, 38. 38. 38, she was there.
For the petitioners, my lord.
38.
For the petitioners. My lord, page number 44 of the petition, my lord. Annexure 812 of the CAT petition. Annexure 812, it is in the page number 44 of the petition, my lord, red petition. 812. It shows the chronology of the career progression of the respondent.
Serial number 38, sir, 42,806.
Which page you say?
44. Shri Ravi P. So the date of appointment was 4/2/1987. My lord can see the scale of appointment. That was the scale for as a driver of 3-wheelers, not 4-wheelers. Subsequently, 1/1/89, he was confirmed in the pay scale of 950,500. Then the date of first promotion was granted on 19/1/1997 after the withdrawal of ACP. On a prefixing mode it was granted, because initially it was given under the assured career progression. It was taken back, and in the regular stream the promotion was. Petitioner is Union of India, Swami. Respondent is Ravi P. Yes, madam. First serial number. Then the second promotion happened in 2008 under MACP, Modified Career Progression after completion of 20 years of service. And the third is due after 30 years of date of joining as a regular driver, which is 1989, 1/1/1989. So the dispute basically is on two accounts, my lord, which the Honorable Cat have decided. Instead of 2008, the second promotion should have been effected from 2004 onwards. That in the grade 1, that is the first dispute. And second, the person, the respondent may be considered for the promotion to the special grade driver. These are the 2 points of contention, my lord. And the first, addressing the first query for the grade 1 promotion, my lord, I invite my lord to page number 31. Which shows, which gives actually the modified version of the original memorandum dated 30th November of 1993. It is modified to the extent to avoid confusion in the number of service years a person have put in the due course of his service. Page 31 is the office memorandum. On the second page of that memorandum, that is page number 32, the government had given a clarity saying that for grade 1 promotion, 6 years of regular service in grade 2, or a combined service of 15 years in grade 2 and in ordinary grade put together. That is the criteria. This is the modification of the para 2(3) of the original memorandum dated 30/11/1993. And my lord, the Honorable Cat had passed orders based on this, considering that grade 2 to grade 1 is a simple promotion. If you put in 15 years of service, you are eligible to be promoted. The Honorable Cat, I'm not sure, it just overlooked the 2.4 of the original clause of this 30/11/1993 order, saying that the person must pass the trade. That memorandum is not attached with this petition because this was filed in 2019. I have checked this petition, my lord, but that memorandum in its 2.4, I have a soft copy with me. Yeah. Yes, my lord. So it clearly states that trade tests need to be passed. And there is no evidence of passing of trade test. It's like simple, the English proficiency, engine repairing and all. My lord, one more kind submission, my lord. In the registry, my name is also shown again as respondent number 3. On actual, the person, the learned advocate friend who had filed the petition is not there in the panel. The subsequent learned friend is also not there in panel. Now I am the only person in the panel. I have furnished the NOCs. So my name may be displayed against all the 4 petitioners.
So, based on expectation, we will.
Abhilash, ABHALS. Yes, my lord, only for R3.
Next.
2510.
Right.
Serial number 40.
I appeal for the appellants, my lords. Lords, challenges of the learned single judge order, my lords. Respondent, my lords, was working as assistant sub-inspector in RPF, my lords, Railway Protection Force. My lords, on 2/3/22, my lords, CBI has registered a case, my lords, against him and another person, my lords, under the provisions of Prevention of Corruption Act and Section 120, my lords. My lords, on 3/3/2022, my lords, the respondent, my lords, absconds. While on duty, my lords, he absconds, my lords. He does not turn up to the duty. There is a message also sent across. He does not come, my lords. And he is kept under suspension, my lords.
Later on, my lords, because he did not turn up at all or reported to duty at all, my lords, department, my lords, proceeded with the rules, my lords, and dispensed with the inquiry and passed the order of dismissal, my lords. My lords, that order was challenged before the learned single judge, my lords. My lords, in the writ petition, a statement is made that the respondent does not have any other alternative efficacious remedy against the impugned order is the statement, my lords, which is made in the writ petition. My lords, writ petition is filed on 28/3/2022, my lords. Para 13 is that statement. On the very next day, my lords, after filing writ petition before this honorable court, my lords, respondent also files an appeal under the rules on 29/3/2022. That is on the next day. He was pursuing two remedies, my lords. One is the writ petition, other one is the appeal. Lords, even for a moment, I'm not saying that a writ petition is not maintainable or anything. It depends on the facts and circumstances and the discretion, my lords, if it is violation of principle of natural justice and some. But here, my lords, making a statement that there are no alternative efficacious remedy, but later on even files an appeal, my lords, they can't pursue two remedies is what my contention, my lords. It's not permissible. My lords, on the merits also, my lords, the provision, my lords, rule provides for dispensation of the inquiry, my lords, while passing a penalty of major, not practical. He was absconding, my lords. He did not appear at all. He was on duty on that day. He admits, my lords. He admits and he says maybe after a week or 10 days, he submits himself before the CBI and after that he takes a bail. During that period, he does not report to the duty at all. He admits there is no dispute about that. Lords, the learned single judge holds that we have not provided any document to show in support of dispensation of inquiry is what the learned single judge holds it and says that though he had only challenged the order of dismissal, my lords, the learned single judge, my lords, set aside the order, grants him all consequential benefits over there. May I pursued, my lords, to see the impugned order, my lords, which was an order wherein, my lords, the inquiry was dispensed. My lords, it does not say in so many words that how it is done or it is dispensed, my lords, though there is a mention about it. Circumstances are mentioned, my lords, clearly in the order that what led to the passing of the order and why it was dispensed, my lords. That order is available at page number 47, my lords. Before that, may I pursued, my lords, to see page 38 for a moment, my lords. In respect of my first contention that efficacious remedy which is there. Page 38, para 13, my lords. Last two lines. Page 38, please. Here action was taken against two officials, my lords. One is the respondent who was working as assistant sub-inspector, my lords, of the Railway Protection Force. Page 38, para 13. The petitioner submits that the petitioner is having no other alternative and efficacious remedy. Petitioner is constrained to approach this honorable court as the dismissal order is passed in violation of principle of natural justice. This is a statement. My lords, the annexure E, page 97, my lords, is the appeal which is filed on 29th of March 2022, my lords. Next day, my lords. WP was filed on 28/3/22. Appeal is filed on 29/3/22, my lords. Annexure E, page 97. My lords may kindly see the subject. Appeal against the penalty of dismissal from service dated so on.
Yes.
And even in the page 99, my lords, para 10. It is admitted, my lords, he was unauthorizedly absent, though he tries to give an explanation. He is unauthorizedly absent from 3/3/2022 to.
Take it all, was your decision, why did you take, it's not practicable.
Lords, that we have recorded, my lords, in the order itself.
Satisfaction, not he.
Please, my lords. Please, my lords, page 47 may be seen, my lords. Please, my lords. Page 47, my lords, this is the order. 9/3/2022, my lords. My lords, page 47, I'll read two paragraphs, then I will take my lords to the other paragraphs, relevant paragraphs. Speaking order. On 3/3/2022, a group of CBI officers led by so and so and so and so post for investigation against Umesh Thakkar and T.C. Raghavendra. Present respondent is T.C. Raghavendra. There were two officials involved, two officials, my lords. So and so in RC number so and so under section 7 read with so and so PC Act. The complaint was made by one Manjunath in so and so. CBI officials have collected the relevant document of BYPL post so and 147 of Railway Act and crime number so and so for further investigation. At that time, Umesh Thakkar so and T.C. Raghavendra were not available with the BYPL post. So and so requested the undersigned for assistance in providing the addresses of the above two RPFC personnel which have been provided by this department, and a control message has been given to BYPL post stating that both so and so to be present but did not turn up at the BYPL post. Hence, contemplating disciplinary proceedings, both were placed under suspension and attached to decoy subdivision so and so by the undersigned minutes. Minutes, next page, minutes, page 48 would be relevant. It was learned from so and so regarding registration of case against Umesh Thakkar and Sri T.C. Raghavendra on 3/3/22 and Sri Shambhunath Singh AAC SBC was directed by so and so to immediately cause preliminary inquiry into the complaint and submit report. On 3/3/2022, when so and so reached the BYPL post at around 19:30 hours, found Umesh Thakkar and Sri T.C. Raghavendra were not available at BPL post, though a control message was flashed to BPL post through DSCR SBC for both of them to be present at the post. Hence, it was clear that both were absent from the scheduled duty without authorization. Lords, I will skip the next para. It is pertaining to the other person notes. And the third para. Sri T.C. Raghavendra, who went to band H/HEB for attending UDR case at 8:30 hours, returned to BYPL post at 12:30 hours and remained in the post. He conducted roll call for 14 hours to 22 hours batch at 13.45 hours, where 4 staff of BYL attended the roll call. 3 staffs were deployed for a menu shed band station and SMBB station, and Miss so and so was deployed for office entry duties at the BPL booth. Further, Sri T.C. Raghavendra did not make any entry in the general diary and was not found at BPL post after conducting a return call roll. Reasons, my lords. Page 50, my lords. Page 50. Lords, relevant paras I will point out, my lords. Para 3, my lords. Further, till date, there is no official presence of both ASI Raghavendra and IPF Umesh Thakkar, and they have not reported to Decoy Bangalore after attachment orders were issued, nor have they made themselves available for attendance after both were placed under suspension on 3/3/22, which indicates that both are absconding. There is no possible reason for any subordinate officer to abscond when the said person is not guilty of charges. Therefore, the fact of the case indicate that misuse of possession of an authority, the said officials were involved into demanding illegal gratification, which tarnished the image of the force and defeats the very purpose of our existence of public service. This is not only misconduct, but a misdemeanor of highest degree, being uniform person, and hence, since the criminal case has been registered and both officials are absconding and there is no information of their whereabouts, deterrent discipline action is warranted. 5. So T.C. Raghavendra under suspension was inducted into RPF in 2006 as Constable RPF and was promoted as ASI in 2/12/2021 and had joined RPF Bayappanhalli in February 2021 back from the training after being promoted. He was posted in Bayappanhalli RPF post since 2/2/2021 and like other force personnel Several written and verbal advisories and instructions have been issued to him to maintain the integrity and dedication to duty over the years. He has failed to maintain absolute integrity, devotion of duty, maintain high ethical standards and honesty, and committed an act which is unbecoming of a railway servant. He placed. Please. Please, ma'am.
If they are not to report you, you should know his whereabouts to ensure they participate in the inquiry.
True, ma'am. But
Where have they gone? Where have they gone? What attempts you have made? You have checked up their residences, they are available there. What? See what happens? Inquiry initiated. You have to ensure their presence in the inquiry. You will issue notice, or you will issue a charge sheet.
true, ma'am.
They will give reply. They must be living somewhere.
They were absconding, my lords, is what they also admit.
They
We
were
also,
not at home also.
no, my lords, they admit they were absconding.
But there, you go, what is the material before you to come to the conclusion? You see, we are testing your action.
True, my lords.
You will not rely upon them who they are responding. They say it's, but what is your basis for you to say it's not practicable? Have they gone missing in thin air? You must be somewhere. Or their whereabouts were not known. You checked up their house. You checked them, whatever the possible location, they were not found. Then even the charge sheet could not be served on them. If the charge sheet could not have been served, it is not practicable to hold inquiry. But was this material there? Did you serve a charge sheet on them?
No, my lords, we are not served.
So without making an attempt to serve a charge sheet, how can you dispense with?
We have
And
stated.
most of people tell you. The opportunity to cross-examine them or to produce them in evidence comes. There can be a situation witnesses are not coming forward to depose.
True.
You will say it is not practicable. Because the witnesses are not coming. See, this is generally in the sense of, where the witnesses doesn't want to depose against the charge. It's not practical. Those are the inquiry. What is this inquiry we have to see? And we have to see what is your subjective satisfaction. What is the basis for you?
True, my lords.
You would not sit in the same, oh, it's not practical. You will merely because you think it is not practical, it's not. But you have to have some material to say.
He has been arrested. It is well known to the department. But the case has been.
He was detained.
No, he has been detained. He himself has voluntarily appeared to CBI that I have not done anything wrong in the matter because I am going to be assisting the department.
That's the famous.
True, my lords.
Also indicated in the sense of 311 to CS. Interest we notify.
Please.
Yes, sir.
And our file is now the details now decided. Allow me to support you.
You have filed it.
Yes, 7/3/2024.
You have filed it, Mr. Kumar.
No, I have not filed it.
Filed it, sir.
2510.
Lords,
2510.
interim order may be kindly extended. Interim order is there till today.
Had a similar set of facts, similar issue. The charging thing to be filed when it is not, when it is pending for. We don't inquire, my lord, all the records which is well within the department.
Interim order may be kindly extended. Much.
You are not saying. Next.
Serial number 23.
Yes, ma'am. Second, you have it on But right, if there is an issue, we want to understand what movement they decide the issue. See, we want to know, actually, we want to know, you may be right, they have 1%, you have 1%. Who has to decide it? We are thinking of a situation, let's assume the court accepts the settlement. What is the position? We are ready to hear it, and that this requires clarity because that proceeding will have a bearing here. Right, man, so what is the version being given by him, by here?
Prayer is not so much, prayer is for abeyance, please, just clarify that.
Yeah, very clear. We are with you in the sense that insofar as suppose minus the mediation, we have to work it out before the NCLT. Just work it out. So just check out. Yes. You know what Mr. Nagaland says? Based on the order.
Let's, I am making a statement. The court cannot compel me for a settlement. Let's, that's a statement which is made by the learned senior counsel. After I have already stated that there is no question of any settlement. There is no question of compulsion. Milords, may I say this, Milords? This is in respect of a writ petition which has already become infructuous. They are enjoying the benefit of an interim order. Let it not be extended for extraneous reasons. Because something else.
Please, my lord. Please,
We'll work it out on settlement.
please,
According to the court, there is a settlement.
please,
Then you will tell the NCS.
please. My lord, as of now, the next date is on 15/10, my lord. In fact, it is not my learned friend's office who is. Please, my lord, now the issue is this, my lord.
Today we are only concerned with this.
Please. Please,
Proceedings arising from the NCLT.
please,
The IBC, na?
please,
Please, Milords.
Under the IBC. You
Please.
will work it out. If there is a settlement, you will tell the NCLT, look here, there is a settlement enter, that's all.
Yes.
My lord, the difficulty was such, my lord, we had, in fact, it's not such a, it's not a simple situation where it's only two parties who are trying to work a settlement. There are so many parties, there's also an invest. Please, my lord,
That's settlement.
please,
That settlement has been entered according to
Please.
signed.
please,
Will that not mean that if it is ultimately a settlement,
please.
then you will tell the NCLT that settlement has been entered, it has become.
Yes.
I have already placed that on record as well, my lord. I've already placed the mediation report also there before the NCLT, my lord. Now, my lord, insofar as that is concerned, now that was, no, it was on 3rd of this month. It is adjourned to 15/10 because the same confusion also was also put forth before the Honorable NCLT also saying that there is a mediation report. It has been placed on record. Now, what is the consequence if one of the parties pulls out from the mediation? That was what had to be looked at there. Now, my lord, the Honorable NCLT also kept note of that and then adjourned to 15/10. There was no opposition from the other side. They said yes. So I'll just make a submission. There was no opposition whatsoever. They only said yes, please have it in the middle of November. I asked for November. They said no, let it be in October. We'll submit it by then. There was no opposition.
But there is
If
stay of
there
the
was
NCLT
anything-
proceedings in this matter. There is a stay of the NCLT proceedings in this matter. There is no question of proceeding there. I can't even make a submission.
My lord, I will show the order sheet also. It records even the settlement aspect. Please.
There is any question.
My lord, but either way, despite there being a stay, the aspect insofar as me settling the matter, my lord, I'm not shying away from it merely because I have a stay. I'm not shying away from the fact that I've told that I'll be settling the matter. I have placed it on record.
Lordships.
Why don't you get a clarification of this order?
Lords, may I just say this, my lords? This is a writ petition which has virtually become infructuous. Now they wanted to take a plea that the interim order should be continued for some other ground which is not the subject matter of this writ petition.
Right.
That settlement, that is not something which was ever considered by the NCLT. The original orders of the NCLT on the basis of whether there is a settlement, whether it comes in the way of the NCLT dealing with the matter is not before your lordships. That's a jurisdiction which is exclusively vested with the NCLT. NCLT has to take a decision on that. So far as the instant writ petition is concerned, they came about saying that we wanted 3 months' time. 3 months' time, your lordships have granted 1.5 years' time for them. So it's the end of the matter. Now, if they feel that the settlement comes in the way of me proceeding with the NCLT proceedings, this is a decision to be taken by the NCLT. Notes, otherwise what happens? The jurisdiction of the NCLT virtually stands ousted, which should not be, my lords. The reason that, lords, your lordships may reserve liberty. If this is what the stand which is being taken by them, let them go and urge it before the NCLT as to whether the alleged settlement.
Please.
Yes.
Now, Mayor, just make one submission, my lord. Now, to say that 1.5 years I have enjoyed the interim order. Please.
So far these proceedings are concerned, everything needs to be worked out. Your
Please,
whole
my lord.
case is on the settlement.
Please.
Your whole, even the prayer is on the basis of the Supreme Court.
Settlement.
judgment in Vidarbha that-
Vidarbha, please.
Saying that the parties must be exploring a.
Please.
settlement.
Please, my lord.
You have a settlement.
Please.
That issue is considered there.
Please, my lord.
If ultimately that issue is decided, okay, settlement comes into play, you will file before the NCLT. Insofar these proceedings are concerned, you are relying upon the settlement, you will work it out there and place it before the NCLT.
If my lords were to just give me a slight in terms of, my lord, here the difficulty is this, my lord. The stand taken here is something else, my lord. Before the NCLT is something else. Now, my lords may kindly see the objections, please.
The basis of which we have filed this petition.
Please.
Your basis of this petition is there is a settlement which has been, settlement, the parties must explore a settlement.
Please.
There is no Supreme Court judgment.
Please.
Okay, the court said very well. Now, in those petition, you say there is a settlement entered.
Please.
Okay. Now, according to them, we don't want to settle it.
Please.
Very well, that court will decide
Please, my lord.
what has to be done.
Please.
NCLT proceedings have been stayed.
Please.
On the strength of this one.
Please.
Now, insofar as this petition is concerned, we say that we will explore it, we will work it out before the NCLT.
Please.
By the time that order comes, settlement is accepted or not accepted.
Please.
If it is accepted, you will show the NCLT, look here, settlement has been accepted. It inter se bites the parties. That's the end of it. NCLT settlement go, NCLT proceedings also go.
Please.
Based on the settlement. How this petition must continue?
Now, my lord, may I just make one submission here, my lord?
the language which is used in the mediation report is such, it is not that if there's a default, now let's assume for the sake of argument, there's a default. But it does not provide a situation for restoration of the proceedings before NCLT. It only says if I do not pay this in terms of this settlement, you can then recover it in accordance with law. Now that is not to restore what is already there. Please, Manoj.
There are NCLT proceedings.
Please.
They have initiated from which these proceedings arise.
Please.
Settlement, according to you, settlement has been entered.
Please.
They disown, which they say we don't want to take it forward. NCLT today, suppose for a moment the court particularly says ki no, this is not binding. NCLT proceeding will go on simultaneously. You will work it out before NCLT. Today, insofar this petition is concerned, what is there to even continue this proceedings?
My lord, again, to show my bona fides, my lord, it is not that I merely went and said that I'm going to a settlement. I did enter into a settlement, but now, my lord, that is being called into question, saying that no, one of the parties says no, we do not want to, because it's a tripartite agreement, my lord. Two of us are saying yes. One party still says no. Now, that is the issue. So, which is why, my lord, please. I have asked for it to be kept in abeyance by what?
I'm really afraid that should not be a statement to be made by him. As a matter of fact, both the parties have said no. Lords, what happened? He was required to complete the entire transaction by 31st. He had to get some documents from one Blackstone who was the investor. That investor is backed out. He doesn't have money. I have to recover 300 crores. Lords, the RBI is sitting on my neck, and every month I am required to respond to RBI what steps we are taking, what steps we are taking. One effort we made, saying that by 31st of March 2024, if he makes good the entire 295 crores, we will not pursue. This is again, we said that it is subject to approval of the board. Notes, he did not pay a single rupee. Then what he started telling, that this is the reason why I am not getting the investments. You have committed something, therefore I am not getting the investments. This telltale stories he started telling because he was not in a position to generate the money. Notes, as a bank, as an asset reconstruction company, I am struck with this 295 crores because he's in a position to dodge the proceedings, not even a single rupee.
My lords, may kindly come to page 34. Before I can come into this, my lord, I also want to place on record that 70 crores has already been paid, my lord, during the interim. Now it is not 295 crores. I have already paid 70 crores.
My lords, 295 crores is dehorse that amount, my lords. This was taken into account. 3 crores is just the servicing of the interest. My lords, 295 crores is the principal amount. 3 crore rupees, what is being paid is only servicing the interest. Please, my lords. Lords, may kindly see, my lords, page 34. Both the prayers have become infructuous. Lords, the first prayer is to issue writ of certiorari or appropriate writ or directions for an order dated 1/3, which your lords will find at page 37. There is no order which is passed on 1/3. And the second one is to give 90 days, that is already lapsed. B, 90 days, it's already lapsed, my lords.
The last part, my lords, may kindly see. Please. Please.
Kindly have a look at this. From filed on 27/2 by adjourning the said case by 90 days. That is already over.
That is pertaining to my application, my lord. I had filed an
Now,
application
if
asking
he
for
wants
90
to
days.
say before the NCLT, that's the reason why I said, my lord, that's the original jurisdiction to be excised by the NCLT. Now, if he goes before the NCLT with all these things to say that the NCLT should stall the proceedings and then he comes before the court, it's a different matter. He cannot introduce under 227 minutes what's transpired subsequently to say that this should be stalled. Writ petition has become infructuous.
Please.
Just see this case.
Please.
Settlement.
Please.
According to the settlement.
Please.
They say we disown it.
Please.
Don't want to go there. That issue is pending there.
Please.
He survives in this.
Please. My lord, nothing, I wouldn't say nothing survives here, my lord. It would, in fact, the proceedings before NCLT itself cannot survive because in terms of the settlement, he's supposed to withdraw it. He doesn't withdraw it. So, my lord, I am here again before my lords because he's supposed to withdraw it, my lord. The mediation report.
If he files an affidavit to that effect through his managing director, my lords, I'll just make this statement. If he files an affidavit through his managing director that we had to withdraw this NCLT proceedings without the payment of the money, and that is his understanding of the settlement, I will not leave any stone unturned to initiate proceedings against him under section 340. He cannot make false statements. Everything was subject to condition that he pays the money.
Based on the settlement, we will withdraw those.
Lords, if 295 crores were to be paid on or before 31st of March 2024, which was again subject to approval of the board, then we said, if you pay the money, then we will not pursue. He did not pay the money. No, we are, if your lordships were to see, what is being serviced is only the interest, 1%. He is paying 1%.
May I again take my lord's attention to para 4 of the mediation report. Please, my lord. Please.
We will, let's.
We'll have to withdraw it, my lord.
Ultimately, my lords,
Next
if
date, my lord, next date is on 15/10, my lord, before the honorable NCLT. Now here, my lord, here the apprehension is this, again, I was not a party before those proceedings, before the coordinate bench. But there, once this stays vacant, the next thing they'll go before the NCLT, my lord. They'll advance the matter and go there. Next stage is only for admission, my lord. My lord, if my matter is admitted, my lord, my shares will drop, my lord, it'll crash. It's a Ritz-Carlton hotel, my lord. I'm not a small hotel here.
lords, my lords, the mediation has not stayed the NCLT proceedings. There is no understanding that we should keep the NCLT proceedings in abeyance pending the conclusion of the mediation proceedings is never the understanding. Understanding even otherwise in the mediation is time bound that as of 31st of March 24, you make good the payment, we will not pursue proceedings against you. It is as good as that. There is no such understanding. And your lordships may kindly see, because this is what we insisted, my lords, before the coordinate bench, since your lordship said so, we got it recorded that we have no settlement in the matter, and we insisted that the matter should be posted for hearing. And the order copy is also now uploaded, my lords. I have produced the order copy also.
Place another order on record, my lord, because this is another writ petition which is preferred by the petitioner company here. My lord, it was because there was a fraud tag which was put on my bank account, which is where the principal investor, my lord, Blackstone, they backed out, saying that this fraud tag is there. Fraud tag was put by who, my lord? Yes Bank. Now, we have an order which we had obtained on Thursday, my lord. I'll have to place that on record also, where the Honorable High Court, coordinate bench of this Honorable Court has directed that the fraud tag be removed. Now, my lord, when this fraud tag is removed, my lord, all my obstacles go. The only thing which I have left is to clear the amount, which I'll say I am doing it.
Lordships may kindly see the third unnumbered paragraph. In company appeal number 509, learned counsel so-and-so is present before the court, physically submits, appellant is not willing to settle the issues emerged between the parties. Last line, my lords, the list these matters on 25/9/24 for hearing. My lords, I insisted before the coordinate bench, the matter has to be taken up for hearing. My lords, the only thing which the court found was because Mr. Raghavan, the senior counsel, objected that section 75 debars the court to look into anything because there is a embargo of confidentiality. That's the reason why the court said that all right, we will look into that also. But so far as I am concerned, in company of the commercial appeal 509, I said I want to argue the matter on merits, and therefore the matter is slated for arguments on merits.
But I may have to just interject.
But now the difficulty is this, my lords, how can they stall the NCLT? Lordships, please. Lords, I'll just say this, my lords. If I have to express what transpired before the court expressed that when the matter is being heard, the court wants to look at the parties and the demeanor of the parties to decide the case on merits. This is exactly the wordings used by the coordinate bench. It is for this reason the coordinate bench said, let the parties be kept present.
He was present. It was present. Authorized dignitary was there, some director was there. Not, it is why settlement.
Lords, the NCLT is on 15/10, my lords. Now, the difficulty, lordships.
We will have it on this 26 with a clear understanding, no further requirement shall be. We then will proceed.
Lords, may I have a look at that settlement which is placed before the court for 1 minute, Lords? Because, Lords, institutions, it becomes difficult, Lords, at all levels for us to answer it. Lords, may I have a look at that settlement for 1 minute, Lords? What is placed? Because with these clear terms, if he is in a position to, Lords, probe it and get the matters adjourned from time to time, it becomes, Lords, may I kindly have a look at that?
Let's be very clear, Mr. Raj. There
Lords,
are audit proceedings which are pending. You are right.
Lords, kindly have a look at that because his entire case, so far as the, Lords, kindly have a look at clause Roman 3
Milord,
at
three-
page number 7.
3 crores
Lords, I'll-
continues to be taken without any protest or demur whatsoever. Milord.
I
3
will,
crores is going
I will
every
show it. I will show. Lords, para 3, Roman 3, Nitesh Residency Hotels Limited as the borrower and JC Flowers Asset Reconstruction as the lender have agreed in principle to settle the debt as outstanding principal amount to be payable by 31st of March 24 and that lender waives off the interest outstanding. NRHPL will continue to pay ad hoc payment of rupees 3 crores per month to JC Flowers till the closure of the loan. JC Flower Asset Reconstruction has agreed to the terms of the settlement mentioned in this minutes memorandum based on the following understanding and subject to its board of directors approval. Lords, now next clause A, that it is agreed between the parties that the settlement between the NHPRL and the JC Flowers as mentioned herein above shall be applicable only in the event that all the covenants contained in this minutes or memorandum are complied with by all the parties. In case of the settlement failing due to non-compliance of the terms contained herein, JC Flowers shall be at liberty to recover its total outstanding debt from the NRHPL because we have waived the interest. Notes, interest is 200 crores. What is next? Next clause B is very important, Milords. It is further agreed that the arrangement contained herein, unless fully complied with by all the parties, shall not be prejudicial to the contentions or averments made by the parties in the proceedings whatsoever. Then clause 5. Upon implementation of the terms of settlements now agreed by the execution of the required documents and payment of the agreement amounts, all 3 parties shall withdraw. Note 31st of March is the date fixed. I have waived 200 crores interest if he had complied with this. Now, my lords, the whole difficulty is he lures us into this settlement.
Lord, may also.
He lures us into this settlement, makes us believe he is going to pay this money. Now he doesn't have the money. He tells stories. Now he wants to put us in a situation from March 2024. Neither I get the money, nor will I be in a position to proceed with any of the proceedings. This is the stand which I am facing before all the coordinate bench are before. Lots I'm sorry, my lords.
We are also conscious of it.
Lots. I understand.
See, we will say this, Mr. Ravishankar.
Lots.
26, no further adjournment.
Milord, may I just make one request? Milord? Nothing more, nothing on, just on the date, Milord, because 26th to 29th, I mean, not 30th,
We
Milord.
are having 26.
If possible, 30th.
Whatever date
It's
we
just 30th, Milord, nothing more than that. If possible, Milord, because I may not be here, that's the only reason.
Please, my lords.
Making clear, no further adjournment.
Because
Please.
that period, Milord.
We take this memo on record.
Please, memo and the order sheet also, my lords. I had to file the memo because the order sheet was not released, but your lords may take both on record. Please.
Copy thereof, I think, which is the same is taken on record. Here, so I will copy of the order date. 23, what is the date?
25/9. 25, 25/9 minutes. Next date is
This
order copy minutes. I'm sorry. My notes is on 5/9. Yes, in the first page itself, the date is mentioned. Please.
Milord,
Coordinate bench in COMAP
509. Please.
just one request, I'm sorry, I'll take about 10 seconds, nothing more than that. 26th is a Thursday, 27th is a Friday. I'm just asking for 2 days, 30th, Milord, that's all.
26.
Please.
Thank you.
Grateful.